boundaries.
Well, it's, tentatively, it's showing for 27th of this month. May not be deleted.
Yes, not to be deleted. Grateful. Interested? No. ये वो वाला है. हाँ. Dated. When the matter was taken up, 12/2/2026, for the exemption from. However, later on, the third statement. No order has been. Accordingly, what is recorded in para 12. Maybe, sir. At 10,000. It has same date.
Lordship, I am mentioning an item number 116. Senior Manan Kumar Mishra have argued the matter, but today is not available due to the family function. Therefore,
You be here when the item is called, you be here and inform us.
I'm appearing for the petitioner as a proxy counsel. My counsel is undergoing a dental surgery, so kindly adjourn the matter, please.
You're going surgery,
Yeah, dental surgery.
dental surgery.
The
Please,
letter
my
has
lords,
been
I'm
circulated.
appearing for the respondent number 2, my lords.
I appear for the statement.
Dental surgery.
Give them toothless.
As paid well counsel for the petitioner. How much time you want?
3 weeks.
3 weeks. What kind of surgery is this? What wisdom teeth is?
I don't know the details, sorry.
Then how will he argue after 3 weeks?
Without wisdom.
Without wisdom. Post after 2 weeks. 2 weeks.
May I please your lordship? Your lordship, I am appearing for the estate, my lord. My lord, in this matter, we have filed the counter affidavit, but has not been taken on record, my lord.
My lords, I am for the state, my lord. We have also filed the counter, but it is not on record.
When have you filed? Both are not taken on record.
Yesterday, my lords, we have filed the counter.
Allowed interim relief.
Yes, my lord.
Yes, my lord, anticipatory
Let
has
the
been-
counter be taken on record, my lord.
Learned counsel for the respondents have already filed counter. Para. Let the counter be placed on record post on Tuesday.
Grateful.
My lord.
For office report, respondent number 2 is not served. I am for the state, problem 1. Yesterday,
Not served.
is it in transit? No?
State has filed counter yesterday, my lord.
I have filed my counter yesterday, but might be, it will be on, not record, on record.
Oh, my lord.
Any short date,
Notice is in transit.
your
According
lordship,
to office report.
lordship.
Await.
My lord, I have copy of counter affidavit of the respondent, my lord. My lord, from 8 years I am behind bars, my lord. My
Wait.
lord, may just.
Since you have joined respondent number 2, now.
My lord, respondent number 2 was in custody, my lord. He in
This is issued, we have to wait. Who is
Lordship.
Respondent
My
number
lord,
2.
respondent number 2 was a complainant. my lord.
Complainant, informant.
But he is in custody. We are in different case, my lord. He has shot someone. In that case, he is already in behind bars, my lord. I have the copy of the FIR, my lord.
You serve him dusty through the jail superintendent.
My lord,
Once-
my lord,
So you have made him a party.
my
You have
lord,
to
he
hear.
was party before the High Court, my lord.
If he is a party and we have issued notice, we cannot withdraw notice subsequently.
Unless you delete.
My lord.
But your-
That in due course, my lord, service. I won't be able to serve him this.
Press notice be issued to respondent number 2. Dusty is also permitted.
Not the steam, my lord. I won't be able to serve him.
SHO.
We don't have terms to. I won't be able to
We
serve.
serve through the concerned SSO.
Lordship.
After 2 weeks.
My lord, may give a specific date, my lord, for my sake, my lord.
Today is 7. 11th March.
Much
Lordship.
of deeply obliging.
Yesterday, I filed my counter. Lordship.
Milord,
Or, my lord.
Milord, yesterday I could file Milord counter. Kindly take it next week, Milord.
Last time the
Against grant of bail.
yes, madam. I am for the complainant. I am seeking cancellation of bail granted to the respondent number 1.
Well,
Counter.
yes, Milord, yesterday.
Morning the
was like,
For which respondent?
I am for respondent number 1, Milord, in whose favor bail is granted.
Yes, respondent number 1 has filed counter affidavit only yesterday. Let the counter be placed on record, post on Wednesday.
98. Yeah, court has it is an argument. Yeah. Court says if it identifies, but no role is attributed to it. So Lange, your statement that TI parade he didn't identify may not be correct. That was the
Yes.
argument.
Yes.
It is identified, but role attributed is not mentioned in the statement is what they say.
in the statement of those eyewitnesses, my lord, they have stated, they have not stated the name of that the present respondent number 1, but the role to who they came on the motorcycle. They gave.
This on which notice issued is
Yes.
TI parade was not identified.
He was identified.
Okay.
He was
He
identified.
was identified. That
He
is-
was identified.
He was identified, but the statement shows that they learned from the newspaper. They learned from the newspaper that they were arrested. They have not seen the, they have not witnessed.
We'll examine this.
Yes,
have to
Milord, I will point.
What is the evidentiary value of the TI parade?
Yes, Milord.
On date?
Yes, Milord.
Yes.
It is after 3 months.
Yes.
Great.
State was granted time to file counter.
My lord, we have received the instruction and the documents
Enjoying interim relief.
Yes, Milord.
Yes.
Just a week's time, my lord.
just away for filing the counter.
Counter. Interim to continue.
Obliging.
23 दिन बाद 23 दिन बाद
Yes.
Our affidavits are on record.
Yes. Not here.
I appear for the state, your lordships, they are cooperating with the investigation. Those are my instructions.
Sir, Lordship Miss Shashi Kiran, senior advocate, she is joining virtually.
Please, Your Lordship, this is a case for cancellation of bail, but Your Lordship, I've just received some documents just 24 hours before, so we just need some time, 1 week time to file the rejoinder, Your Lordship.
A rejoinder to their counsel. And counsel for the,
Yes,
counsel for the petitioner, post in the next week.
Great, I'm okay.
May I please, Lordships? Lordships, in this matter, I am seeking a regular bail.
Hmm.
3 out of 5 co-accused has been enlarged on bail on the similar footing.
Yes,
The charges has been framed, charge sheet has been submitted.
similarly placed?
Yes, my Lordships.
Yes.
When my name is not states in the FIR, I would just request for 1 week's time, my lord. We have sent the counter for execution, my lord.
This is third time this is listed.
I'm sorry, my lord. There's been a change in the IO also, my lord. So there's a gap in instructions, my lord. That's the only reason. However, my lord, the case of the state is that, my lord, that the petitioner was a contract killer. Basis his confessional statements, the murder weapon was seized, my lord.
Next week, file it in the next week.
Next week we'll file, my lord. Next week, my lord.
Let counter be filed within a week, post in the next week.
Very much
Keep your
obliged.
My lord's requesting a passover. My lord's main counsel is on his legs in court 11, my lords. Oh, my lords, I've filed my counter yesterday itself in this. Maybe not on
Lords
record.
on the last.
Pursuant to my lord's order,
You are for the,
I appear for the state, my lords.
who is for the respondent? Number
Number
2?
I am there.
My lord, I am for the respondent, I am for the
File
respondent
counter?
number 2, my lord.
Lords, I am for the.
I'll seek time for
petitioner.
filing counter, my lord.
We are concerned
My lord,
more
I
with
may
your
permitted
counter.
to file counter affidavit, my lord.
This is the second FIR by you.
My lord, I'll be
Second
filing
FIR he was
I'll be
released
filing my
earlier.
counter, my lord. I'll be filing my counter.
And see, he is harassing you.
My lord, I'll be
According to
filing
My
my
lords,
counter.
I am for the petitioner. My lords, on the
Have
last
you seen the
day,
pen drive, that video which was submitted?
My lords, it's not submitted to us, my lords.
No.
I'll call for it also.
Must be in touch with the IO.
I'll call it, my lords.
My lord,
Because my lords had considered on the last time the
Because
age.
the High Court also says that
Please.
respondent produced a pen drive containing video recording in which
Please,
petitioner was seen performing vulgar act.
Other
And
activities.
Please, my lords.
because if that is found true, probably we may not make absolutely interim order.
I can bring that in a sealed cover as well, and I'll myself also look into it. If
See, ladies are staying in
yes,
the
my
house.
lords. Even on the last occasion, my lords, the only thing what persuaded my lords was the age of the petitioner. Otherwise, my lords,
my lords, there is nothing as such.
But
My lord
you
had
are behaving,
completely gone
as
through
in
the-
an appropriate manner.
1 week
I'll file my counter along. I'll bring it, my lord.
you want.
My lord, 2 weeks, my lord.
Post,
1 or 2 weeks.
Lawrence,
taking 4 weeks.
One number 2 is allowed 2 weeks time to file counter. Post on 9th March.
Would my lords want me to bring the pen
interim,
drive?
my lords, interim.
Would my lords want me to bring the pen drive? I'll update.
Make a statement, we'll believe you.
Very
My lord.
obliged, my lords.
My lords, interim to continue.
Interim to continue.
Much obliged. My lords.
Your Lordship, my counsel is on his legs in another court. I request a short passover.
Pass over.
Obliged, Your Lordship.
Yes. Because it will be interesting.
I know, I say, maybe I say that. Whenever I have to say.
21, yes. Pass over.
Notify किया
नहीं हाँ नोटिफाई कर
notify कर दिया
क्यों चेक ना नोटिफाई कर दिया ना सीक्वेंस
22 is a regular bail application.
यस
There's a suicide note that is found 12 days after the actual body is found. It
You
is
are called
found.
Patwari.
I am a Patwari.
Patwari.
I was outside as 250 kilometers away on the date of the incident. Because my wife,
but you subjected her to cruelty a day before.
there's an oral statement made by the family members
Yes,
of the
oral
wife.
will be there. Who
I bowed down.
records the statement?
So two things of note, madam. I am not at the spot at the time when the incident takes place. I'm at a place 250
Need not
kilometers.
be on the spot.
I bow down. The body is recovered on the date of the incident on 2nd of June. A suicide note finds its recovery on 14th of June. And that suicide note, Millards, is
That one.
it's
PDF
there.
95 is
Please, Millards, straight away.
116.
94, which is the English translation, 95 is the original Hindi.
Annexure.
This is Annexure Piece 7. Annexure P7. It's also extracted, my lords, in one of the orders passed by the Honorable High Court. If your lordships have page 260,
there's a typed version at paragraph 8. हम बहुत मजबूर हैं.
You married me for the property, that is the statement.
That's the allegation, Milord, and may I say this? This particular thing is in a
Yes, sir.
photocopy situation. 21 witnesses cited, 1 witness has been examined, Milord, still today. I have been arrested in June of 24. I continue to be in custody, Milord, and I was actually not even there. So that, and may I say this? I have placed records to indicate that she was having detailed conversations with somebody else who's an ex-friend of hers. So those call detail records are available. All of that was placed. There's an alternate theory, because I'll face that trial.
Ligature also is upward point.
That's right.
Notice.
I'm obliged.
Double in 4 weeks.
I'm obliged.
Anyway, it can be unnatural.
Malad sir, anticipatory bail.
Point soon before is the main point.
The case of anticipatory bail, Malad. All the accused person in both the FIs, the case of cross affair, Malad, they are on bail, Malad. In both the FIs, Malad, 6 accused person from the other side, they are on anticipatory bail granted by the London Sessions Court, Malad.
Anticipatory bail 307.
Malad.
Injuries on head.
Malad, I even petition is the person who has sustained the injury on head, Malad. And there are several other injuries also. Even from my side.
Injury number 35.
Yes, Malad. If Malad can.
Means there is at least minimum 35.
Yes, Malad. If Malad kindly have page number 51 for a moment, that is my injury report. Even I have sustained so many injuries. My head was, Malad, 5 centimeter cut was around my head, Malad. And all the accused person in both the.
And apply for regular bail. Not a case for anticipatory.
Then Malad, kindly protect me for some time, because all the accused persons are on bail, Malad. Malad, it's a matter arising out of the land dispute.
Liberty is resolved to surrender and apply for regular bail.
Land dispute doesn't mean you can go and hit somebody.
Grant me 4 weeks. I'll.
Yes. Next.
Oblige.
So,
if it's a regular bail, Lordship, the offence is under POCSO Act.
Then one after another.
Lordship, he's an auto rickshaw driver. He is from the lower strata. If he is under the
Everything in the auto rickshaw itself.
At 53 years of age.
52 years of your Lordship.
And she's 13 only.
Yeah. Because our main contention is he has been falsely implicated. If he's under jail, he may not be able
your friend
to contest.
And she is helping you. But not a case, it's very difficult.
150 days he has been in custody.
Since 13th September 25. Hardly 5 months.
Hardly 5, not at this stage. You withdraw and move later.
Not at this stage.
Permit me to withdraw the SLP.
Counsel for the petitioner is permitted to withdraw the SLP with liberty
may I request
for the trial court at an appropriate stage.
Yes. May I seek permission to hand over my appearance memo?
Physical appearance. Yes.
May I please, my lord?
Yes.
This is somewhere in 1928. The lease was given to my lord Jalaluddin, and there was a decree.
Time you want?
19.
Time, 3 months.
Only 2 minutes, my lord.
2 minutes.
No.
No more time.
For vacating, you will pick up the hint.
Kindly see, on the basis of which the High Court has recorded finding in 1976, Patta was awarded.
You see,
Patta was
in the question of law framed by the High Court. Come to the question of law.
Yes. Whether the
in a case of landlord-tenant, where the landlord is seeking eviction and the decree is concurrent by trial court and first appellate court, now read the substantial question of law.
the state government and the state would have been a necessary party.
What is this?
For 2 reasons, my lord.
What is this? And then see para 15 of the High Court order. Your admission about his ownership. He is enjoying a Najul Patta. That Najul Patta, you will say it's a government property. Dismissed.
My lord, this was the case.
Yes.
Where the High Court, my lord, only.
It got some issue. Otherwise, to clear, I think it was an error only. Mr. Vashish, earlier, it won't be res judicata. It was an error which was correct.
Milord, annexure A5, if your lordships may kindly peruse, there was a finding of Milord that there is relationship is highly in doubt. And Milord, that finding has not
Admit that they were related to Gopinath and there is a partition.
Yes, yes.
That's right, Milord. But there is again, Milord, a question, a serious question which has been casted on the partition deed itself. And that has been recorded, Milord, if your lordships may see from para 18 and 19 of annexure P5.
Here the other side, we will issue notice.
Lordship, please.
Could your lordship?
Only
I'm
this-
appearing. On KV.
Here you file counter.
Lord, my respectful submission is that all this has been considered in the original eviction order of 5th of March 2019, paragraph 11.1.
For some time.
I'm sorry, my lord?
You satisfy us
Yeah,
that
your
the
lordships.
earlier order
Your lordships.
on a typographical error only and it won't be res judicata.
But that is noted in the impugned order.
You want to?
As my lord, please. As my
4
lord.
weeks.
Leave to defend is denied, no?
Yes,
The leave to defend was denied thereafter.
Then reviewed.
So we must be satisfied.
19, my lord, the original eviction order came to be passed in my favor.
19.
And thereafter it was reviewed in 19 itself. And thereafter, my lord, the matter remained pending in the High Court for 6 years, my lord.
Of the presiding officer, it was reviewed.
That's right, my lord. That's also. Plus, I was only respectfully urging, my lord,
Issue
that
notice to the-
they've been sitting in the property for the last 100 years.
Accepts notice. Appears and waives notice. Para.
Milord,
The counter affidavit be filed in 4 weeks. Post on 24th March.
lordship, please. Milord, till then, because they have filed the execution also.
In the meanwhile, petitioner shall not be dispossessed
Lordship,
from the
obliged. Great.
premises, from the
Your AOR goes by the same name?
Yes, Milord.
We were also wondering. The only difference is A. Vishishta and Vishishta.
She is a senior. AOR also coincidentally is the same. I thought you will accept brief only if the AOR name tallies.
Who is benefited, you or AOR?
Both. If I would read a judgment, Lords, I would congratulate both of them. Then one of them would message to say that it's not me, it's the other money. And that was the reason, my Lord, 2007, we met, my Lord, only because of our names being common and somebody calling me and wanted to speak to him.
There's a new movie coming in where Paresh Rawal is playing double role.
Very good. Solid actor.
Obliged, my Lord. Grateful.
Hilarious. Double role.
Yeah.
I should have given permission to serve the ASG. I have served the magistrate office. I have served to the ASG magistrate. Last date.
Which item is
There is no any response. Reply not filed, magistrate.
Contempt.
Contempt.
Magistrate.
Online forms is not accepted.
Magistrate, actually,
Or
yeah,
have you served them?
yes, yeah, I already served.
Name is appearing?
Vikramjit Banerjee was asked.
Yes,
Yes, I served. Magistrate. Office report also, magistrate.
You have informed him. He knows it about the listing today.
Circulate and call him at 2 so that.
तो सर्कुलेट कर दो
Name.
नहीं कर दो नहीं
Banerjee.
विक्रम जी
Hello.
That's it.
Hello.
Yes.
Sorry. Also, Chandrasekhar is appearing. Chandrasekhar, just unmute.
I am for the petitioner, my lord.
Yes.
My lord, in this case, the High Court, the only ground why they denied granting specific relief is, my lord, they said this is the only source of land and but again, immediately after the impugned order, he has again entered into an agreement of sale for selling the property, my lord. Very same. Out of 10 lakhs, out of 10 lakhs,
Correct. Exactly. You are,
total,
you are
total
getting it along with 12%.
Nobody
My
would have
lord.
given you in the bank.
My lord, 12, I am ready to pay more also, my lord. But out of 10 lakhs, 86,000, substantial amount, 90%, 9 lakhs I already paid on the.
That is why it creates, the
Now,
antenna goes
when
up
the-
that it is a money lending
When the
transaction.
entire amount, almost entire is paid and there is no sell lead instantly, that means there is something fishy.
No, my lord. Actually, now again is entered into an agreement of sale. Immediately after the impugned order, he assured me that some documents were required. Some documents were required for agreement of sale. He said he'll make the documents
you.
ready. My lord.
Thank you,
My lord,
rightly refunded all.
My lord, I'll produce the recent agreement of sale, my lord. Please see
That
after
will not help
immediately after
you. In this case,
Please,
that
Lord.
evidence is for another transaction. That will not be an evidence in this matter.
But immediately after the
Once
impugned
it is
order.
concurrently done, we
Yes.
should not.
My lord, immediately I'm ready to pay more also. Shipmate can record my submission, my lord. I'm ready to pay
You
whatever
approach
your
him
lordship.
that if you can sell it to some other person, what the other person is giving now, you will pay more than what the other person is giving him. Yes.
My lord.
Next.
Yeah, it's an item 15. It's now ultimately we have settled it, Milad, and we have filed a joint.
My lord. The prayer is this, my lord. My client is coming, my lord. She is stuck in the traffic, my lord.
Consider, Mr. Manoj Mishra.
Yes, my lord.
The agreement is there.
Yes, my lord.
Visitation right once in 3 months for 3 hours and not come with musclemen for 4.
Why it is there, my lord?
No, it is not in the interest of the child. It's not about winning a case, please.
Saying, my lord,
Child will not have wholesome
Yes, my
development.
lord, we are fully agreeable, but
Even if you agree,
Let it
we
be
don't have
once
to
in a
put
month, at
imprimenter
least
of this.
yes, my lord, I am agreeable, but you are
To say that he will not come with musclemen, what kind of thing are you doing to a child? I mean, you fight till eternity.
Page 20, you lord,
He comes with a muscleman.
only to page 20.
3 months, once in
I
3
agree
months,
to
how
everything.
I am ready for that.
To do, Milad,
That's
I have
why my client is coming.
Lordship, may see one thing.
Page
What
20,
to do?
Lordship, just see
Milad,
page
the-
20. 20. Page 20. Why this has occurred? Why this has occurred? Page 20.
Right, even they are having an ego battle, you must advise them.
Well, I have advised my lord. That's
Come
why.
at 12 o'clock, advise and come. We will
Yes,
do
my lord.
something.
She is coming at Lordship may take up at 12 o'clock, my lord. It is agreed by the first party that the venue of Miti Kumar will be the bring with the third party stranger, muscleman, weapon. Only the one additional family members, my lord. What happened? Every time they create a scene, and I'm not coming on the way. My lord. I'm not coming, my lord. I will advise my client. She is coming, my lord. Lordship may take up at 12 o'clock. She is coming.
Agreement, we won't have to put the imprimatur.
Yes, my lord.
We'll say that this is opposed to public policy. You better advise her.
Yes, my lord, I will advise, my lord. At 12 o'clock, your lordship may take up. She is here.
Lordship, do one thing. Milad, whatever your lordship, Milad, deem fit, Lordship, may Milad.
Will long, father will long, nobody will be benefited. Only visitation, a phone call, give something. You are having the.
I'm ready, my lord. We have cooperated every time, my lord. Every time, my lord. They are actually, my lord, why this class was put?
That para, once in 3 months, 3 hours, no muscleman, no gun.
No gun and no
Read
stranger.
that. Read which page is that?
Page 20, my lord. Page 20, just V application filed, my lord.
From E.
Para CE. E for England, my lord. England, last 3 lines, it is at the top of the page 20, my lord. Why this clause was put, my lord? Because of so many problems were created by them, my lord. Even, my lord, lordship may just.
Today he should not say all this, Milad. I am paying also. Leave everything.
Explaining that why this clause was put up. I am not coming on the way, my lord.
Amount also, Milad, it's exorbitant.
I am not coming on the way, my lord. I am fully agreeable. I am not coming.
I am leaving.
Why this clause was?
Say one thing,
My
Milad.
lord, there was.
I am leaving to your lordship, Milad. I am leaving to your lordship, Milad.
That's why.
What is he doing?
My lord, actually,
Milad, I am handicapped. There is a record.
Please allow me. My lord, he is a businessman.
Why? What is the background of this clause?
Yes, my background of this clause, my lord. Every time, my lord, whenever he is coming with the gun. He is coming with the muscle. Allow me. That's why you agreed for
all this,
my lord.
Proof of
Today, because of honorable court, my lord, he is saying that.
because I have to get it out.
He agreed. He agreed everything. My learned friend, whatever is saying, my lord, I will place everything on record. Everything on record, my lord. Because of traffic.
You rework that clause.
Yes, my lord. Which clause, my lord?
This clause,
That second clause.
visitation right clause. It can't be once in 3 months. It has to be on a more frequent period.
I'm leaving to your lordship, my lord. Whatever your lordship.
Both of us.
She is coming at 12 o'clock, my lord.
Sit together and sort out.
We have, my lords,
That's why we have solved it, my lord.
We'll record joint statement.
Joint statement will record on
Because this
visitation.
is, you see,
Give telephone call daily, give weekly once, and then sort it out so that the child has wholesome development.
Yes, my lord. We have no problem at all, my lord, because of their past conduct, my lord. Even with a gun, with muscle man, he was coming and.
Don't believe all that the clients are saying. We have all had
No,
clients.
my lord,
we have to do it. We have done this.
was on record. That's why we have agreed on this, my lord. I'm just, she's coming, my lord, at 12 o'clock.
We go by the cab rank rule, not that, whoever comes to me is an angel. Don't have that notion at all.
Yes, your lordship is right, my lord. I'm not saying anything, my lord. But your lordship may take up at 12 o'clock, my lord.
He has come first to you. If she has come first to him and he has come to you, it's a different story. That's all. As simple as that.
My lord, at 12 o'clock, your lordship is taking it, my lord.
We were finalizing it, my lords. Of course, my lords,
Already enough.
did not agree.
You just sit down and sort it out.
we take it first 12 o'clock or something.
It gives them more time to solve.
Post lunch.
Yes, my lord.
Khatam.
2 o'clock?
2 o'clock.
2 o'clock.
Highly obliged.
Definitely wholesome development.
With great respect, Lordship, item 16, Lordship, is a transfer petition on behalf of wife, Lordship. Here, we are seeking transfer of matrimonial proceeding, Lordship, divorce proceeding from Madhya Pradesh to Bihar, Lordship.
No counting.
Maharaj, I have instruction that we are in the process to settle the matter. Maharaj, I'm seeking some time for that.
Lordship, we have no
Go
instruction.
for mediation.
Lordship,
Mediation has
it's
failed.
only- Lordship, the girls is want to ready with live with the husband, but Lordship, he is not ready.
Maharaj,
He's saying then again send to the mediation center, Lordship.
yes, Maharaj. Maharaj, Maharaj, may grant me rights for
although-
appearing online.
Yes. As per mediation report, mediation has failed, but learned counsel for the respondent submits that there are every chances of amicable settlement between the parties. In view of the above, that the parties again initiate the process of mediation to the Supreme Court Mediation Center. And for that, they shall appear before the same mediator.
Hello.
Same mediator on, because he will better understand.
Yes.
Yes,
Once he has interacted with you on 27th February.
Lordship, it's a physical.
75.
It's a physical meeting.
Maharaj,
Whatever you
VC,
decide.
VC would.
If you want to appear,
Lordship, it will be better than the parties may be called physically, Lordship, because the earlier this was through.
Better.
on the first date, the parties shall appear before the mediator physically, and thereafter either virtually or physically as directed by the mediator.
Much obliged.
Post it on 4th May along with mediation report.
Lordship, some expenses may be ordered, Lordship. She is not doing anything, Lordship. She's unemployed, Lordship.
125 application that is
Pending, no, there is no order.
As and when the petitioner is required to appear physically before the meeting.
What are you doing?
She's a housewife, Lordship.
She's a teacher, Maharaj. This is a
What are you doing?
Maharaj, I am an accountant. I'm working with the Tata Motors.
What are you doing?
Mood maintenance.
Yes, no, Lordship, there is no order of maintenance.
They have filed a
Child is there?
125
Yes,
application.
Lordship.
Child is there?
No, there is no child, Lordship.
10,000 is there.
Also, Arvind, physically before the mediator, the respondent shall pay a sum of rupees 10,000 to the petitioner, 10,000 per hearing, public per appearance.
Yes, if I may just point out, Malad, he is earning only 40,000 rupees, Malad, per month.
10,000 once, whenever she appears, not per month. Whenever she appears physically before the mediator, you will pay. So
Malad,
only once appears, you will pay once only.
I understand, Malad, may grant me some time, I'll seek instructions to that effect, Malad.
It's our order.
Malad, he is earning only 40,000.
It's not a consent order.
Tata Motor, you said.
Sorry, Malad.
Home must be 40 after all deduction. Take it from me.
Yes.
Great.
Complete है ना sentence? Per appearance, per appearance.
Actually, the mediation has
Your
failed.
Lordship, say please.
Mediation has failed,
The
Lordship.
wife seeks transfer of the petition for dissolution of marriage filed by the husband from Principal Judge, Family Court, Bahadurgarh to
Bahadurgarh to Agra.
Yes, Your Lordships.
Any other proceeding pending in Agra?
No, but it's another
Only proceeding.
well, it's another proceeding under DV Act has been filed by the mother-in-law of the petitioner, and it is connected matter listed before your lordships today. 17.1.
So the other matter is also at
Bahadurgarh. Bahadurgarh.
Lordship, just look at the grounds. Just wondering. The petition filed by the mother-in-law under DV Act in Bahadurgarh, and the ground they are seeking for transfer, Lordship, just they are very important, Lordship. Just see that grounds.
So it's an offshoot of the dispute between the husband and wife.
Grounds only against husband.
should have settled it instead of.
We should have settled it. That's the that
Have
would
you
have
put
been
the
better.
mediation?
No doubt.
Mediation has failed. My lords,
Mediation has failed.
Another round of mediation can take place in the transferee court.
Yes,
Here only you come. Senior
transfer petition allowed both.
But there is no child, nothing. They can. Her brother is here in Delhi.
All the more a good reason that you should have settled and parted.
We should have
ways.
settled. That's no doubt, bro. That's
Yes.
like
10 not.
Grateful to you.
10 not
10 not
before.
before.
That's why I was wondering what. Then I can't hear.
10 not before. लिखा है ये. You have already informed.
I'll inform. So that you don't read it.
Yes, yes.
One more final hearing is there.
But 2 weeks before a bench in which one of us, brother का नाम लिखिए, is not a member.
much appreciated.
Yeah, please.
Yes.
Well, this is a matter pertains to acquisition of land for the purpose of refinery in 2007. Some basic facts, I'll just pass on one piece of paper. Malad.
They claim 7 lakhs, but the court has granted 10 lakhs.
Court has granted 10
That's
lakhs.
the only ground.
Two things which the High Court has done.
That we have a judgment.
The
That it will be a fair compensation, not that what they are seeking,
so the
but what they are entitled for.
I'll deal with that. 2-3 things which I want to point out on this. The total land which was acquired was 14 hectares. This was owned by 110 people on this. I'll just give the details. These are relevant. Just pass on. Do a copy.
आपको फैन थोड़ा नीचे है स्ट्रेट करने में आप
Piece of paper for a minute, Malad. Total land acquired was 14 point some odd hectares. This was owned by 110 people. 101, they have what the reference court gave. They have taken money, gone home.
Total land mentioned?
Total land is on the third line. I'll just read this note. It is pertinent to note that the state government, on the request of the BPCL, issued a notification under section 4 of the land.
15.2176.
Yes. 142176 hectares of land. But let's kindly note this was owned by 110 people. 101, they have the reference court, whatever awarded, they had taken and satisfied. Further, it is pertinent to state that the 9 respondent in the present SLP holds about 1.38 hectares, which is 9.7% of the total land. That is under the contention today, Malas. How the land initially was allocation was made was
Others are not aggrieved.
others are not aggrieved.
Out of 100 and
110 Malas.
110, only 9.
9 are aggrieved. Now, land was categorized in 4 categories at the time of acquisition. The categories are given, Malas. Category 1, dry land having the road frontage. Category 2, garden land. Category 3, dry land having access to pathway. Category 4 is the without any access. And the price, my lords, can see as per the per RA. The unit is not acre, my lords, RA. And it has got some conversion factor to it. The reference court enhanced to the figures which are given. What is paid is in the High Court is 7,41,000 for all. High Court has awarded 10.
Bar.
All
that is required is we have to assess the correct market value.
Absolutely. Yes, yes.
And if necessary, additional court fee will have to be paid.
That is a matter of fact has been subsequently paid. That's no issue on that part, Manas. 2 things I want to point. And just to complete this, the lower half of the table, these were the comparable sale deeds which were considered. And if my lords may see on the extreme right, these were picked up from the which category they belongs to. A5, A6, A7, A8, A9. Now, for all, the price per RA is also given. What the High Court has done is, and I'll come to the reference court order. What the High Court has done is, High Court has done 2 things, Malas.
What is the date of acquisition? 2007.
2007, Malas. 20th September 27. High Court says that all these sample A5, A6, A7, 8 has not been considered by reference court. That's factually wrong. 2, the method of categorization or belting done at the time acquisition is wrong. 3, blanket that I go by A9, which is giving the land, the price per RA is 10,17,441, the last one, serial number 5, which is exhibit number A9. And therefore, I apply 10 lakh. That's the basis or reason which has been given. Now, second, the
closest to the acquisition also.
Yes, yes.
1 month before the acquisition.
Yes,
2 months.
All
2
these
months.
all these are also the close one. These are not very different.
No, this is
1 month before
this is
4/1.
August. Acquisition is September.
I think 2 months, my lord. The other one, A5 they have relied upon was 6 months prior.
A9 is 1 month,
A9
Mr.
is
Chale.
20th
Yes.
August.
Yes, it is 20th August
And your
2017.
acquisition is
yes,
September, closest.
Yes, this is the, in that way, it's closest. I don't deny that part. The first is that the High Court has appointed a court commissioner. Court commissioner gave a report and gave a reason which were considered by reference court that the why the certain roads have been, certain lands have been.
It is not exorbitant.
Exorbitant. How much, any deductions, development charge deduction?
No, Malaj,
Because your refineries, what are you going to keep?
it's for refineries.
So no development.
Yes,
Health
yes.
and principle.
Plus, kindly see the land which A9, which has been considered based on which this it has been awarded is, this document is available at page 58. This was fully ready commercial land for construction of apartments.
Which document? A9.
A9, because that's the basis, Malaj. Page 58. It starts from page 58. Malaj can take it that 58 is the one which has been considered. And the relevant part which I want to read in terms of what was the nature of the land which was there. Page,
Annexure.
I'm sorry. Annexure A, P1, Malaj.
You see, it is 10 lakh per RA.
Per RA, yes.
And the total affected area is 1.38 hectares.
Yes.
How much it will be in RA?
RA would be, I'll just give you. Just pass on this.
My lord, 40 RAs is 1 hectare.
Conversion factor, Manoj. Just
So how much?
the
3 RA, 4 RA, what?
yes.
It is
So,
air
2.47 cents, my lord.
air. It's 138, Manoj. 1 is equal to 138. If we see, acre is 100 cent. The table which I have here.
Just tell me.
Acre to hectare you have to
Acre to hectare.
100 RA is equal to 1 hectare, Manoj.
RA
is 1 hectare.
Yes.
So this is how many hectare? 1.38.
1.38.
I think it's not a.
Well, the issue is I would have certainly told them that not to go ahead. The issue is because the all other are which are closed, they are sitting on the fence and subsequent.
Actually, 28A principle will apply for.
Well, and therefore that's the reason I want to justify that this is not right for the reason because court appointed a commissioner. Commissioner physically verified this land. It was identified in these terms of categorization which have been done. This court has held that the
difference is 3 lakhs per RA.
Yes, difference is 3 lakhs per RA, which is there.
That means that means 3 crore only. For 100 RA.
No, it has to be multiplied into 9, Malas, because there are 9 the petitioners who are there. 9 land.
It is
total extent.
Total extent is 1.38.
No, 14 hectares.
For 9.
Yes, this
no, total extent is 14.
14
For these 9 respondents,
only 1.38.
Only 1.38.
1.38 is equal to be. Let's kindly see 2 things now.
Reality is there. That means if your exhibit A9 has fully developed lands,
yes,
and it is proximate,
yes,
these lands have potentiality.
Potentiality can be one argument. I don't deny that part. So far as the land,
not BPCL, Mr. Balbir Singh.
Yes,
the issue is that
all Maharatnas and Navaratnas you have to pay when you people take land.
They have been paid the rate which they asked for, where others have been granted.
Market value also, my lord.
That's what I'm saying. Kindly see the comparable, which is A9. Kindly see A9 annex to P1 for.
This is going on since 2007-8. The value in 2007-8. Now the present value will be at least
100 hours is 1 hectare.
As a matter of fact, this refinery has been set up. It's the expansion has been carried out. I don't deny that part.
You are in
hereafter it is all for you only. All OPEX, CAPEX over hereafter.
Yes.
Full
massive expansion also.
Any infrastructure project
the full potential.
Full potential for you, money for them.
No, the potentiality has been taken into account, but the comparable taken is wrong. That's my respectful submission. Because if we see the other one,
brother correctly put, it's a fair compensation and it's not exorbitant. And ultimately, they ask for 770. You have got a sale deed for 1017. 10 has been given.
770, my lord. We are confined that claim. Actually, 5 lakhs per cent we claim. We said that we are unable to pay the court fee. So that's what it is.
I think I can clarify. 5 lakh was claimed in the beginning itself in the first round where there was no question of a stamp duty which has been there.
Just imagine they are all holding this much.
Yes.
They claim they have to pay court fee. So they say we can't pay court fee. We will now confine to this. Very often they say if it is increased, we will make good the deficit court fee.
That's it.
Because
Simply.
Yes. No, kindly see one thing, page 62 for a minute. Kindly see page 62. I can understand
Correct.
Because kindly page 62.
Yes, page
62, Malaj, which is part of the A9, which is the comparable sale deed which has been taken based on which the 10 crores has been awarded. 10 lakh has been awarded. First line from the top. Vendor shall at all times indemnify and keep the purchaser indemnified against all claims, debts, so and so interest. Third line, Malaj. In the present contains proving or found to be incorrect and incomplete is not performed observed by vendors if any right, privilege and so and so. 8. Further can be constructed to the said property without conversion of user land.
This means already NA permission given and not constructed could be constructed.
Yes. No, this is comparable.
That means the potential. That means
it's a change of land use
land
granted in those cases.
Yes.
No, this was a change of land use granted in those cases. This can't be compared the land which can't be constructed.
Property is not a low-lying land and is not cultivated.
Correct. So this is, whereas all these are low-lying wetlands, where no
Not low
construction.
lying.
No, no,
Not
I'm
a low
sorry,
line.
this is comparable. I'm saying this is exemplar, not applicable to this case. That's my case. This is not the concerned sale deed. Now kindly see the finding of the court commissioner regarding this land malus. How can this be compared where the change of land use already been given? A land which is ready for construction for the commercial purposes, whereas the wetland which has been acquired for the refinery purposes, which is where there is no pathway to road to that.
And they were the ground crops, etc. Which are, there is not a wetland. No, this is not wetland. This is a wetland.
Acquired land.
Which means agriculture is source of livelihood gone. Wetland means.
All of the even if we look at the source, that's not a claim even made by them. This is not for use for any agriculture purposes. They have been stating this. There is an affidavit file. I can read that affidavit. Kindly see that the finding given by the LAC court so far as this particular land is concerned, page 144. Description of this particular land in question today is at page 144. And then the court commissioner's report has been considered. 144, para 22, Malas. Only 2 paras I'll read. I'm completely conscious, and my intention is certainly not that what is the market rate, they should get it. I'm not for a minute suggesting. But at the same time, it should not be compared something with the land actually is not a matter of fact, not comparable. Para 22, Malas. Para 22 and 23, 2 paras I'll read, Malas. That'll make it clear. Para 22, the entire property is covered by the notification was divided into 4 categories of land acquisition. Officer, category 1, I've already given that, Malas. I'll not get into it. Middle of the page says the High Court directed Special Tehsildar to conduct the site inspection. Now, what is the outcome of the inspection is para 23 on next page, Malas. That is going to be relevant. Para 23, the Advocate Commissioner filed Exhibit A3 report before the High Court was examined as AW5. According to the Commissioner, he inspected the property in survey number 23445 and 23414 of the so-and-so village and identified these properties with the assistance of the village officer. In the report is further stated that the Tehsildar, Revenue Inspector and Village Assistant were also present at the time of inspection. The Commissioner report is appended with the rough plan, and from the report and a plan it can be seen that the means of access through the pathway have a width of 1.15 meters available to both the properties. The properties so inspected by the Commissioner, which are comprised in survey number so-and-so, are the subject matter of reference in both the cases. The Advocate Commissioner who filed Exhibit C1 report has also stated that the property is provided with the means of access from so-and-so road.
There's means of access.
There's a pathway which is there. Now, after comparing all this, kindly see the A9 which has been picked up, how it was compared in the reference code. Page 149, page 147, para 32. After examining all the lands, why the reliance on A9 was discarded. Para 32 on 147. Relying on A8 and A9, the learned counsel for the claimant vehemently argued that land value shall be fixed on the basis of said document. But on going through the Commissioner report itself, it can be seen that both the said properties are having the advantage of the direct access to tar road, the comparables. Admittedly, the means of access to the acquired land is only pathway, which is not at all sufficient to take a 4-wheeler or heavy vehicle. So naturally, they cannot be. Yes.
He adopted the belting system.
Yes.
He adopted the belting system.
Yes.
BESCO. Yes. Belting system was done away with, saying core purpose is the purpose of acquisition.
So the BESCO simply said that the belting.
This finding you are reading.
Yes.
To support his belting theory.
Yes.
Correct or not?
Yes. So the belt today
that belting theory was given up in the by the High Court for a good reason.
No, the High Court, if we look at the High Court is for the reason which has been recorded is, as my lords are aware, that when the land is scattered over and not for uniform purpose use, the belting can be applied. There is a subsequent judgment. There are 2 judgments which are there. The land which has been allocated for one purpose, which is to be used, which is, let's say for the CLU has been done, it's to use for a construction purpose, belting can't be applied in those cases.
That is why what you are reading now is part of the order of the reference code.
If you come to page 147, para 30.
Yes, 31.
A9 is reference.
Yes.
Yes.
That's a finding.
Certified copy of the sale deed.
Yes.
by which an extent of 87.70 RAs of land was sold for a consideration, and that is how they come to 10,09,000.
Yes, but how they.
Next paragraph, para 31.
Yes, 31.
Last 5 lines, Commissioner has further stated that the property is covered by A5 to A9 situated at a lower level of 15-20 feet than the adjacent level. The Commissioner has further stated that the property covered by A9 salient and the acquired property involved in the present case are comparable to each other.
For the comparability benefit, para 37 gave the advantage of 30%.
This is what Commissioner says.
Yes, 30, para 37 and 149, 30%.
What is the perversity?
But 30% is enhanced based on this para 37, page 149. They are asking for further enhancement.
1,000 is deducted, 10 lakh round is given.
Yeah, 10 lakh round is given.
Well, and if my lords kindly see, once as a matter of fact, after preparing maps and tables, it is found that there is only access is a pathway.
It may not be 10 lakhs, maybe 9,80,000 or 9.75 or BPCL for 25,000 or.
I'll humbly submit
the expansion project.
See from that point of
Huge
view.
expansion.
Having heard and counsel for the party.
And all petroleum residue is converted, Milo.
We are not inclined to entertain.
May I request only lastly?
The SLP is dismissed.
It should not be because the otherwise we
Therefore, we are not passing a reasoned order. You see, we discussed it.
So all I'm
discussed it. I asked my brother whether we should pass a reasoned order or a simple dismissal.
Because I only one
Because
request.
if we pass a reasoned order, then you will be in more difficulty.
That's the reason. I'm saying please at least state that this is in the facts of this case. If anybody has got a claim, they have to claim that.
Having heard and counsel for the parties and in the facts and circumstances of the case, we are not inclined to entertain this SLP according to SLP.
Oblige.
Well, at least this should not apply to any other case.
You can't say that.
Yeah, that may not be correct.
28 capital A.
If it is comparable, that it will apply.
Recently, we have given Banarjee judgment.
So I'm conscious. The issue is only that 2007 acquisition today, assuming for a minute that then the project become unviable. If that is otherwise, I don't think the state at that point in time would have been gone for this to acquire this land at that point in time.
Next.
Very well.
Rejoinder is ready, my lord. It would be filed during the course of the day.
Issues of maintainability, rejoinder apart, they have to show that it is maintainable.
That will have to be argued, man. That will have to be argued.
West Bengal.
Yes, ma'am, that was argued on the first day. Thereafter, notice was issued.
They'll have to justify, my lord, how an agency can be weaponized like this.
No, agency is not weaponized. I'm sorry.
Rejoinder was not filed.
Agency has been terrorized.
Filed during the course of the day. But it will be filed.
It's violation of the enforcement directorate, my lords.
Here, if they have filed it today,
No,
we have
but I will also address on great constitutional principles with little understanding I have. But kindly have it on some other day.
After Holi or?
After Holi. After Holi.
Then after Holi, my lord.
When you want?
Because
after Holi,
Sibal, Dr. Singhvi, everybody with their limited understanding tried to persuade your lordships on 32. But
No,
still
but
notice
let my
was-
I think my learned friend is a little harsh in saying limited understanding of the council.
Let it not aware, but I'm
Let him not say that, not because of the word limited understanding, which may be justified,
trying
but for the reason that your lordships recorded my submission in the order, saying maintainability will be fully open. That my learned friend has forgotten.
true, my lord. That is
His instructing counsel should have told him that.
Understanding enforcement
hear you.
directorate's fundamental rights are violated.
Here, all of you.
Yes, my lord. Please do that. Please do that.
Forget that.
I must say, my comment was not addressed to Dr. Singhvi.
No, it was.
He knows that, my lord. There is
Whenever
no
such
doubt.
No, it may be entirely justified, brothers. I am saying it's entirely justified.
Such comment is for all, including the bench also.
No, Lord. Not, I can take exemption. I was not there at the time.
Yes. 20?
But now, no notice, no notice.
No,
What is that?
my lord, it's a PR.
But a very questionable character who's come.
A filer who's been multiple
Here-
times disallowed.
Questionable.
PILs in multiple occasions, is a busybody.
We'll keep it together.
26.
We are not doing anything in that.
Please take it on that day, brother. Please take it on that.
Busybody, my lord.
Rejoinder has been filed. Not filed.
Filed, my lord.
Filed during the course of the day.
Learned SG would submit that
Of course, service.
that the rejoinder is likely to be filed today.
Yes, during the course.
Likely.
Likely, my lord. Very true, my lord.
Likely to be filed today. Full stop. post the matter on, yes, tell us the agreed date.
Much, my lords, after the holiday.
Whatever, my lord, she finds it convenient. Rest of us will adjust, my lord.
After Holi, my
Before Holi or after Holi?
After
Rest
Holi,
of us
sir.
will adjust.
After
whatever
Holi, my lord. After Holi.
The arguments it seems, my lord.
Holi, after Holi.
After Holi suits you.
After Holi, yes.
We'll adjust, my lord. All Mr.
My lord,
Dr.
the
Singhvi,
light
all
will
will
taken up,
Like
like,
colorful after Holi.
my lord, just likely to be taken up, should not be taken up lightly by the learned general.
19th is a Thursday. 19th is a Thursday.
We know nobody is taking.
Nobody takes anything lightly, therefore we are here. We don't take things lightly, therefore we are
10th
here.
March. 10th March, Tuesday.
Please, sir.
19th.
My lords, would your lord
Lord, would-
consider
11th,
9th?
11th?
My lords,
11th March.
19th.
Yeah, my lord, my lord.
11th March.
my lords,
12th
consider
12th, my lord.
19th. 19th.
Any.
February.
19th
No, no,
March.
no.
Yes.
I have no difficulty, my lord. I am free.
Very well.
19th.
Very good.
19th is a Thursday.
Yes.
It should be on 17th, Tuesday, so that
And don't have it on Tuesday, well, have it on a Wednesday, Thursday, well, like today. But Tuesdays will be a little,
Wednesday our regular roster is affected.
because your lordship knows on Tuesday, well, somehow. Any Wednesday, Thursday, your lordship like.
Tuesdays are, my lord, I joined my learned friend. Tuesdays become unmanageable, my lord, for
Actually, well,
everyone.
this final disposal
The
concept.
lists are also long and, my lord, it is
We
really difficult
We
for.
understand it is unmanageable. When it is too
19th
much, it is unmanageable.
No, my lord, to reach everyone, everywhere by the lawyers is
That's very true.
This 19th or well, is the
Eh,
next week, 20,
Mm.
25th, 26th,
18th March.
18th.
18th.
March.
Right.
If you
Very well.
continue, it is
Very well.
spills over, we'll have 19th.
Very well. Very well.
Yes,
Maintainability is very.
Yes.
Grateful, my lords.
never, you.
20th will be along with.
You adopt a submission. What
26th
maintainable is
along
that?
with. 26 will be heard along with.
19.
18th.
1819.
See,
Item number 26 shall be heard.
item 13, what you had asked for my presence in.
My lords,
request.
my lords, there's a
One
bereavement
minute,
in,
18 which is called out has a letter circulated because of Mr. Lord. Unfortunately,
18 कौन सा है?
but the letter is not on record. There's a bereavement in the family of.
18? 18 देना जरा.
I have not appeared in 18, no?
Lord,
No, no. Probably heard it sometime.
just check out.
Your lordships had passed the order in the
Your
matter.
lordships have.
Hearings back.
This is going, Lord, and pass the order. This very matter.
so
What
your
is
lordships,
this?
we were to
Some
file,
IA is posted.
yes, so we were to file an response to this IA.
Bereavement.
State. As unions reply, I was going to say in the course of the day, but your lordship may say likely to be filed, learning from what happened in the
In
previous
every case,
one.
we'll say likely.
Please, my lords. So we'll file it today, my lords.
Only union can afford to say that.
Hearing is always likely.
But first week after Holi,
As paid, 4 weeks time is allowed to learned ESG for filing counter to IA number so and so.
Please, my lords. We'll give the
To
number.
IA post है ना? Post the matter
25.
on 24th March,
Lordships.
It's item 13, lordships had called for me.
item 13.
Tuesday, could it be 25th?
Is your,
Wednesday, Lord?
is your opponent here?
Lord, instead of
Malad,
Tuesday, Wednesday,
I'm,
25th.
I just saw the ticket. It's
One
a
day.
fresh
My
matter.
lords, can it be a week thereafter?
25th.
It's a contempt matter, lordship.
25th, thereafter long vacation.
My lords, can it be a week thereafter? Mr.
24th is fine, Lord.
Mr. Amit Anand Tiwari's.
My lords, it could be a week
accommodating-
thereafter, in
We
April
have
some.
given a longer day.
Yes, lordship may have it along. March.
More than a month because of that one.
March, 25th March.
No, sir, it's
a-
March. That's fine.
I see. Would your lordship consider having it?
My lords,
first
but
week?
week there,
April, my lord.
week thereafter, my lords.
ठीक है, we have no difficulty.
Mr. Natkani,
Yeah, yes, 7th April. Let it be
very
7th
well.
April.
Grateful, my lords, grateful.
Asked for me, Malad. There was a contempt matter against the PF,
Kenila.
PFO. I saw that there was a ticker.
Password, call password.
Malad, are not taking up item 13.
No, immediately it will come. It's in password.
Wait, please, Your Lordship.
Wait for 2 minutes.
But I'm not marked on it, my lord. I'm just present because lordship had asked me presence.
No, there is an order directing service on you.
Oh, I didn't
You
know.
wait for 2 minutes.
We will give you all that.
Item 9.
You are in a hurry, it means to go into some other court?
Please, Your Lordship. Your Lordship, this is an after notice matter.
Is not filed?
Counter has been filed, Your Lordship. I have received copy of the counter.
What do they say?
Your Lordship, in the counter, they said that petitioner number 2 was the one who was making the video. What my respectful submission is, Your Lordship, when Your Lordship was pleased to issue notice, I pointed out that this submission is wrong. That
Number 2 is mother-in-law.
no, Your Lordship, petition brother-in-law, yes,
Law.
brother-in-law, Your Lordship,
One is
mother-in-law.
father-in-law.
One is father-in-law. He's 68 years old. Now, Your Lordship, when this honorable court was pleased to issue notice, I pointed out this fact that this is just a submission that he was making video. Now, even when the counter has been filed, a bare statement has been.
We wanted to sue the dying declaration.
Yes.
Because you were not having that dying
Yes,
declaration.
because it is an
at that time.
anticipatory bill. That has not been produced, Your Lordship.
Yes, Your Lordship, I've asked for the dying declaration. They have not given it to me yet. And with regarding that video recording, the alleged video recording, it has been recorded by petitioner number 2, who's absconding. So they are not even able to recover that.
Your Lordship, this is what my respectful submission, that the submission made by
The
the
counter also is not on record.
No, Your Lordship, it's on record. We filed it.
Counter is in the additional diary.
You need another copy.
वो दिया था तो वो ट्राइपॉड ने दिया हाईकोर्ट ने वन इज बटन But we can take it next week on Monday.
They have not taken out copy from me. So, आज आपके साथ है ना, so they are relying on you that you.
No, they have uploaded. They have uploaded.
Let counter be placed on record. Let counter filed by the respondent. Only one, respond number 1.
Yes, Your Lordship.
Be placed on record. What about number 2?
No one has entered appearance. There's no number 2.
There's only one petition.
There's only one
One respondent, Your Lordship. The other respondent were, Your Lordship, the co-accused, Your Lordship. Your Lordship has not issued notice to them.
Post the matter on Wednesday.
Meanwhile, I'll file the dying declaration also, Your Lordship.
Place it on record. Only for that we had issued notice without granting interim relief.
Yes, Your
Please,
Lordship.
Your Lordship. Obliged.
Obliged, Your Lordship.
Interim relief is still to them. Kindly be explained.
That 12 and 13.
Interim order.
12 and 13, interim order to continue in that date of hearing. Yes.
Obliged.
Malad, I've seen the order directing for it to be served on me. I haven't got a copy. Malad, I'll now take service. I'll take instructions.
Mr. Vikram is the counsel, additional ASG, appearing appearing for the respondent.
Yes.
Pursuant to our order dated 19/1/2026, is allowed 2 weeks time to seek instruction.
Yes. Obliged.
Post the matter. You have received copy now?
It's the soft copies are available, Malad, so we.
Post the matter
That's how I.
on what date?
Any date.
23rd March.
I
don't. Date?
Yes, Your Lordship.
Keep saying it.
Accommodation as the main counsel is
21? You want time?
Right.
2.63 crores as paid post after 2 weeks.
May please.
Yes.
Lord, there are two special petitions. That is, Lord, special petition number 1001 of 2018.
Use the mic, Mr. Yadav.
Mike, use mic.
And second SLP is Lord 10532 of 2018. Lord, the first SLP arises out of an order, Lord, by the trial court, where the preliminary Lord, issue was decided in my favor, holding that the trial court has a jurisdiction, against which the respondent municipal corporation, Lord, filed
3 SLPs.
2 SLPs, Lord, only 2.
No, 19.1 and 19.2.
Which is the connected? It's not mine. I have to. It's not. It's not mine.
Huh? The diary number is contempt petition. One is contempt petition. 19.1 is the contempt. Only 2 SLPs are there.
Blood, I have
Before my learned friend starts, I know. There is an order passed by your lordships on 21st of January 2025. It was heard for quite some time.
I will not miss that order. Definitely,
25 of?
I will respond to that.
2nd of January 2025.
25.
Yes, my lord. 22nd January.
I'll just give the.
Second paragraph onwards, my lord, it becomes relevant. Heard Mr. Counsel for the parties, Mr. Sundaram submits that there is no document whatsoever indicating parts of Usgaon village panchayat forming part of the Kolhapur Municipal Corporation. On the other hand, Mr. Navre submits that this is a untenable plea and that the petitioners must be compelled to face consequences of such a submission made without any basis. There is a reason for that. We direct the state of Maharashtra representing Srirang Verma to file a detailed affidavit enclosing all the documents that are indicated in paragraph so and so.
Your orders also?
Ground, Mulad. I have prepared a short list.
But what probably he is intending to say is
Maharashtra is-
that this report is necessary.
It has no, government has filed affidavit.
Report is already filed.
Not on record notifications.
I will respond
Lord,
to that.
And Milord, one more important thing. Milord, although their witness admits, although Milord, all through.
Don't argue.
Let him open.
But whether this report is filed?
Yes, Milord. State has filed.
I filed 2 reports.
You have seen the report, no? So you will deal with.
I will respond to that.
You will deal with it.
I will deal with everything. Mulad, I have prepared a short list of dates also. Before that, Mulad, I will just give the brief Mulad background. But on 29 January 2013, one public notice appeared in the local newspaper saying that there are some unauthorized constructions and within 30 days that should be demolished.
Why should the government not decide? Instead of court deciding,
Milord, the government
this is
not
such
a
an
part.
issue,
Milord,
whether this particular area falls within the control and territorial jurisdiction of a panchayat or a municipality, it is solely within the discretion of the state government. State government is the best authority.
Yes.
Say it is all within the state's domain. So instead of court deciding it.
Yeah, absolutely right. Your Lordship's Milord, when the matter was pending before the High
Sorry to
Court.
interrupt.
Direct the High Court, direct the Secretary Panchayat and Secretary Urban Bodies.
Your Lordships, for a minute, may say page.
Together and decide whether it belongs to the.
It is done.
That is already done.
Your Lordships may see page 70.
Honorable High Court directed, the report was submitted. Despite that, they came here. Even before your Lordships
for a moment see page 17, para 28, that what your lordships were referring to. Page 17, para 28 of the impugn order.
And Lord, it is our specific case that village panchayat is set up by the persons who have carried out unauthorized constructions. Lord, this is only, my lord, the proxy litigation panchayat is, my lord.
Let him yes, the case because it is Mr. Verma. We thought state government has something to say because of the 22nd January order. Otherwise, he has to open.
Yes, my lord, that was done in the High Court even before your lordship that report is filed.
MMC Act is Maharashtra Municipalities Act.
Have you challenged that notification, Mr. Jadhav?
Lord, there is no question of any notification. There is no notification. My lord, my learned friend did not allow me to. My lord,
No, we will hear you. We'll hear you.
For the petition.
But just to understand and crystallize the issue, para 20, there is a reference to a notification issued.
I am grateful to your lordship. When that I was just my lord, narrating the facts. When that notice was published regarding illegal, my lord, the unauthorized constructions. The first time, my lord, they have, my lord, tried to assert their right, municipal corporation, over these lands. All along, these lands are part of, my lord, Uchka village panchayat, which is the petitioner before your lordship. My lords, we have not challenged section 3 notification. In fact, there is no such notification on record. No section 3 notification. The High Court has proceeded on totally erroneous basis that there is a section 3 notification. Kindly see the, my lord, my prayer in the suit. It arises out of the suit. Yes, my lord. Suit is pending. Now, if your lordship sees page 51 of the SLP, my lord, the prayers are there, my lord. Prayer B, my lord.
This is some 711 proceedings.
Yes, not 711. My lord, in Maharashtra, my lord, at that point of time, there was section 9A.
Section 9A, my lord, regarding the jury.
In capital A.
Yes.
That was later of CPC. That was later deleted.
That issue was decided in my favor. Now, please see the prayer. Have I challenged the notification? Section 3 notification. The entire discussion of the High Court is on section 3 only. This declare that any property out of the suit property has not been included within the limit of the defendant body. Declare that the limit extension claimed by the defendant body has not occurred or has occurred by wrongful, illegal and unauthorized means. This is my case. There was no such extension of their municipal limits. Section 3 of the Maharashtra Municipal Corporation Act talks about to declare any larger municipal area as a municipal corporation.
Now your suit has been dismissed. Your suit has been dismissed.
Yeah, because of the this
the ground
High
civil
Court
court has no jurisdiction in view of the notification which has not been challenged.
Effect of
the area
the
is within the Kolhapur Municipal Corporation.
Yes.
Gram Panchayat has no jurisdiction over the land.
Yes.
Therefore, suit is not maintainable because
the High Court says I cannot challenge section 3 notification, but there is no such notification. Kindly see the public notice of 2013. There is no notification. What they say now, Mulad, when they were state government was not party in the lower court and in my suit, the state government was implicated as a respondent here before your lordships. Your lordship directed the state government to file an affidavit.
This 14th August 1948 42 notification?
Yes, I'll come to that.
I have annexed to my affidavit. I'll take
may I place before lordship the short list of dates?
Very short issue. You only reply to whatever we are asking. Not a such lengthy case. We have to see the notification, whether this village is covered in this notification or not. If it is covered, you are uncovered.
Just excuse me.
Yes, you need water.
Yes, sir.
You need water.
My lord, my learned senior, Mr. Sundaram, pointed out para 10 and para 25 of the High Court judgment. My lord, there, my lord, the High Court relies on those, my lord, 1942, 45 notifications. My lord, those, my lord, kindly see the affidavit, compliance affidavit of the state government, that I will take your lordship to that affidavit, my lord.
That's in the additional volume.
Yes, my lord. That is, my lord, affidavit dated 29 April 2025. Lordship, have a separate small paper book, my lords. Here is it.
Page 8 is the annexure notification.
Yes, my lord, there are 4 annexures. My lord, R1 is 1942. This is all Marathi, my lord. It doesn't refer to my survey numbers. R1, R2. Now, R3, my lord, page 32.
Why don't you read the affidavit and deal with it?
Please, my lord.
Just read 7
Yes,
pages
my lord.
only.
It's a reply affidavit.
Yes, my lord.
I will read the direction of 22nd January.
किधर है वो 27 नहीं हमारा उनका वो गवर्नमेंट का एफिडेविट एक मिनट I'll just that para 2 mulad. I say that this honorable court by order dated 22nd January 25 as directed as we direct the
Affidavit filed by them.
It says your lordship.
by the state
affidavit
government.
pursuant to order dated 21/1/2020.
Yes.
This order is quoted here, Malad. Relevant.
I say this.
Direct the state of Maharashtra, Representative Mr. So and so, to file a detailed affidavit enclosing all the documents that are indicated in para 10 and 25 of the order impugned before us. The documents will include the
For my learned
1945 notification and other
background to this order
notifications
was, I'm sorry.
indicating the correct position of the land claimed by the petitioner, village panchayat, not forming part of the Kolhapur Municipal Corporation. I say that the present dispute revolves around the question as to whether survey numbers, these survey numbers out of the suit property, are included within Kolhapur Municipal Corporation or are comprising of Utsgaon Village Panchayat. I say that while impugn order dated 13/10/2016, the High Court had directed the present state government to look into and resolve the present dispute. A hearing was conducted of all the concerned in this regard. I say that the pursuant to the hearing conducted by the respondent state government, a report dated 7th March.
Para 8 is clear.
In fact, the High Court had directed the state government to mediate between these two public bodies, and they passed the order on merit, my lord. And without, in my absence, my lord, that's.
Now you come to para 8.
Para 2. Para
8 subclause.
Yes, my lord. Para 8, I say that as per order dated so and so, the submissions on behalf of the respondent as per the available record and documents are as follows. As per notification number 18 issued on 14/8/1942, a declaration was made to the extent the limits of Kolhapur Municipal Borough under the provisions of section 7 of Kolhapur Municipal Bureau Act. The said notification of 1942 is available in original and was published in Gazette dated 24/9/42. A true and correct copy is annexed. This is Marathi. My survey numbers are not mentioned there in this notification. The notification dated 30th June 1945 was published in Marathi language as mentioned above in newspaper Pudari in issue dated 18/7/45. A true and correct copy of the original published notification is annexed herewith. And this is a newspaper report.
What is your interest? What is your interest? Gram Panchayat interest.
This area belongs to Gram Panchayat area. This
What
is
is your interest? Whether it is belong to a panchayat or a municipal, how are you affected?
I'll tell you.
It is not your property, not your vested right. You are not the owner as such. In that
parties to the
proprietorial sense.
No, this is only for the interest of the people to whom
People will be benefited, whether they are in corporation or in panchayat.
No, my lord,
yours is affected.
not only mine, kindly see the parties of the suit.
You are not a natural person,
Plaintiff
so that your property is taken away by the government or by anybody.
We are, my lord, we, nothing of that sort.
Then go.
So, Gram Panchayat as well as the private, those persons whom permission is granted, they are also party in the suit. Plaintiff number 2 and 3 are the persons to whom the permissions have been granted, proper mulad that they have.
It will be granted, it will continue if permission is granted. The municipal corporation will continue to grant it.
No, the problem is about the, so far as the, you are right. It doesn't matter the Gram Panchayat, whether it is Gram Panchayat, but these taxes to run the other mulad, give the public amenities and all. Gram Panchayat needs taxes, revenue. If it goes to the municipal corporation, then mulad, what is the revenue mulad? Then it is all along. First mulad, since beginning, never, it was never part of the Kolhapur Municipal Corporation, mulad, the municipal area.
2013.
And mulad, there is not a single document to show that this was mulad, the ever mulad, the included in municipal area of the Kolhapur Municipal Corporation. I will satisfy your lordship. Mulad, recently I have filed an affidavit also. That shows, in fact, this is also only that time, 1945, the land, only the urban land was included and not the agricultural land.
Yeah. 80, 50.
Yes, Mr. Yadav.
Yes, my lord. Now, if you see, my lord, page 32 is, this is the newspaper cutting in the newspaper report. And here, my lord, they refer to one that, where is that? Page G, my lord, below mentioned revision survey numbers lands where streams, nalas of Ujgaon. This is only the newspaper, my lord, that's page 33. And then if you lordship sees page 34, that is not Bhag 5 in English, it is part 5. This is important. Kindly mark this because I'm going to show your lordship that this only the urban land was included, not the agriculture. And we were, my lord, our land was agricultural land. Here, my lord, whereas by so and so dated June 1945, published in Mulad 30th June 1945, they refer to this Gazette notification. It has till date, it has not been Mulad produced by them, except this Pudhari, this thing. Mulad, I admit that our survey numbers are mentioned in this notice. Now, Mulad, kindly come to my recent affidavit, Mulad, dated 27 January 2026, Mulad, the recent, where I have pointed out this part 5, this Gazette, only that time they are saying, Mulad, some 1945, that this land was, Mulad, some included in the, that time it was, Mulad, Kolhapur Municipal Borough, thereafter Municipal Council, and then now Municipal Corporation. So that time it was included. Mulad, kindly, Mulad, have this my additional affidavit I have filed recently. They have not replied to that. Not a Mulad, this 1945 notification they have not produced on record. Assuming that my survey numbers are there in that notification, Mulad, then Mulad, kindly come to this recent my affidavit. We could lay our hands to this Mulad Gazette recently, Mulad. See, this being very old documents, Mulad, 42, 45, well, it's with great difficulty we could find this, Mulad. Now, if your lordship sees, affidavit, just 2-page affidavit. My lord, lordships want, I will read out to you. Lordship. Yes, my lord.
This your reply affidavit. Your reply affidavit.
Abhi recently 27. Yes, my lord. Additional. Yes, my lord.
Reply affidavit of petition number 2.
Yes, please, your lordship.
Yes.
That recently, my lord, on 27 January 26, my lord, I have filed it. My lord.
Which Paragraph?
Paragraph, my lord, 2, my lord.
This is by Trilok Panjumal.
Yeah, I Uzgaon village panchayat, yes, the same thing, my lord.
Yes.
My lord, para number 1. I say and submit that I have read a copy of the affidavit filed by the state government dated, my lord, 29 April 25, which we just read out, my lord, and by Collector Kolhapur dated so and so. I reserve my right to so and so. Para 2, I say and submit that I have already filed my affidavit in reply. I am filing this additional reply as I have procured and obtained a certified copy of Kolhapur Government Gazette dated 26 July 1945 recently. The said Gazette has published a public notice dated 18 July 45 by the then Chief Administrator Karveer. Kolhapur is to be called Karveer that earlier. In the said notice, it was declared that. Yes. Yes.
49
Section
of
3 notification is there.
which act?
The MRTP.
MRTP Act.
MRTP Act. Regional Town Planning Act. But that I was reading
Now
this.
this area is under the MRTP.
Yes, it is covered by Milord MRTP that way covers Milord whether rural, urban, everything is covered under the
It has been
MRTP.
declared a dumping ground in that plan.
Yes, it is declared Milord reserved for the truck terminus and yes.
Jadhav,
No, just
but I
read.
understand. You have to focus on what the issue
Yes,
is.
no.
You have filed a suit with certain declaratory reliefs. 9A was filed, 9A was
Rejected.
dismissed, Kolhapur appeal. Their case is, it is barred because we have issued notifications in 1946. First draft in 24/9/42 and 21/3/46. These areas are included and this is under section 3 of the act, which has enlarged the area of municipal corporation. Public notice only reflected what was in the notifications. In view of that, 149 will bar the suit.
Definitely.
High Court also at that stage, they asked representatives sit together. They also came and said it's part of the municipal corporation. Here also it's part of the municipal. Your rightful course will be to challenge the section 3 notification under that limited opening in Justice Shetty's judgment. I was noticed that Barjatia's case, Kalyan municipality matter, I think. Then after you succeed, you can establish all this. In the suit, it can't be decided.
So provided, and I am completely in agreement with your lordship. My lord, you of that judgment, my lord, Sundar Jas.
Lal Barjatia, Justice Shetty's judgment. If you say.
Lord, we cannot challenge that notification. Number one, that notification is not there.
Unless
But
the
even-
procedure is not followed.
It's
a
not there.
conditional
Or
legislation.
no, even. But my case is, there was no such notification in respect of these survey numbers. That's what I was pointing out. Just one para, allow me to read this my affidavit. And that gazette, my lord. That
One second.
I did not, my lord.
Yadav feels that he's not getting opening at all. He just.
Mr. Naure, you will have your audio.
Wait.
So their own witness.
He just made only one statement.
He is blocked either by us or by you. Yes.
Mr. Naure. My lords. Just allow me to, I'm sorry. That this my lord, my affidavit, short affidavit, 1 page I want to read. Para number, I submit that the entire contains the government gazette dated R2 and
Which para?
para 5, my lord. Just one para, and I will take your lordship to that notification.
R1 of the affidavit.
As per the city development and declaration 10/54, which is to eastern side of Karveer, now as Kolhapur, it shows the entire land as an agricultural land which was not anywhere affected by the declaration mentioned above, and that area was not acquired or included.
You are reading from para 5.
Yes, my lord.
Para 5 of your reply affidavit.
My reply, my lord.
It says annexure just to the affidavit contains a gazette notification.
No. Reply of petition number 2 or
This is
But your
petition number 1.
no, petition number 2.
That starts, as my brother says, it starts with annexure
R1
R1 of the affidavit.
You said some agricultural land, this, that. It is not there in para 5.
But there is additional affidavit in reply, my lord.
Additional reply affidavit, additional reply affidavit.
PDF 378.
Yes. Additional reply affidavit of petitioner number 1.
As per
Petition number 1. Follow. Petition number 1, my lord. Just
Yes, para 5 you are reading.
yes. As per the city development and declaration 10/54, which is to the eastern side of as an agricultural land, which was not anywhere affected by the declaration mentioned above, and that area was not acquired or included into Kolhapur government. This annexure R2, and this English translation is of Kolhapur Government Gazette 26 July 45 has also been attached herewith. Kindly come to the English translation. Page 8, Milad. The public notice, Milad. On the part 5 कुठं बघितलं होतं आपण पार्ट 5 पार्ट 5 बघितलं होतं ते
हो हो
कुठे ते
हा ते पार्ट 5 ह्याच्यामध्ये आहे ना आहे
भाग 3 आहे ना
नाही तो त्यांच्या ह्याच्यामध्ये स्टेट गव्हर्नमेंट केस नाही पार्ट 5 ह्याच्यामध्ये स्टेट गव्हर्नमेंट ह्याच्यामध्ये
नाही आपल्याला ह्याच्यातून त्याला रिलेट करावं लागेल ना ते
हो
हा ठीक आहे मला दिस पब्लिक नोटीस काइंडली कम टू पेज 8 to all residents within the city of Kolhapur and adjoining areas of Kolhapur, Moje, Kajwadi, Ujjwalwada, Ujgaon and others settling. It is hereby informed that an additional area has been acquired for the city development below the settlements under declaration number 10 regarding this was published in the Gazette part 5. That is the Gazette Mullah, the government affidavit Mullah relies on. They are relying. Page government affidavit, page 34, part 5. Page 138 on 3/3/45, the so and so resolution so and so has sanctioned conducting a city survey. This city this public notice, page 8.
Yes.
Public notice to all residents within the city of Kolhapur.
So this is public notice in connection with what proceeding?
Yeah, this one, they refer to this government gazette part 5.
No, not government gazette.
No, just the same. This is a government gazette.
Inclusion of the area or for some other purpose? Because it says that bailiff went and there was some obstruction. What for this?
No. That we are not concerned with that part. Sometimes the gazette, other things are also mentioned. We are concerned with this part.
With page 8. Public
Yes, sir.
notice.
Yes, my lord. Public notice to all residents within the city of Kolhapur and adjoining area of Kasba, Bavda, Mauje, Jadawadi, Ujjwadi, so and so. It is hereby informed that an additional area has been acquired for the city development below the settlement under declaration number so and so regarding this was published in the government part 5, which is that Mulad, the Bhag 5, that government gazette. On 3 the dated 18/11/45 has sanctioned conducting a city survey for that area. This city survey is applicable only to land used for purposes other than agriculture. No, the map I have annexed this map also, page 11. they have not responded to this reply, my lord. When I have said that those notifications.
You continue.
That gazette. Now this suit was filed by the Gram Panchayat as well as two individuals to whom the constructions were given in representative capacity. They were also included. This Mulad area is about 4 lakh square feet construction is already done. This Kolhapur Municipal Corporation, first time they have issued this public notice in 2013. Mulad till date, Mulad, they have not been collecting any. If they had documents or this land was included in 1942, there should be some record like this collecting property taxes, some area development, road, etc. Nothing was done. Only may I take your last to the High Court, Mulad, totally on erroneous basis. There is no Section 3 notification. Nothing. And this also I have, Mulad, pointed out to your lordship. This is, Mulad, the agriculture land. Not that map is also annexed, Mulad. They have not denied this.
Yes.
No, just one more thing. In case, Mulad, it's not whether, Mulad, this so far as this, Mulad, the individual owners or those who applied for the construction, and now there's a cloth market, big cloth market. 4 lakh square feet construction is already done. Not 150 Mulad businesses, 50 Mulad constructions, and there, Mulad, there are about 5,000 employees are there. And there, Mulad, the main source of living is the income from this house. In case your lordships, Mulad, come to the conclusion that this that we don't mind, Mulad, going to the corporation, but that this doesn't belong, that this doesn't fall under village panchayat, or we cannot challenge that gazette notification.
You don't, your panchayat. Don't forget.
Yeah, no, panchayat as well as.
I mean, individuals are also plaintiff number 2 and 3.
I have learned. I'm an advocate for both Gram Panchayat as well as the.
That we have understood.
It's not Gram Panchayat concerned.
You are wearing
But
2-3 hats. Panchayat hat and that Vyapari hat.
No, espousing the
Encroacher
cause
hat.
of both Gram Panchayat as well as these people. Because so far as the Gram Panchayat is aggrieved because they will file Mulad proceedings to recover the taxes or other Mulad or compensation, etc. But so far if the Gram Panchayat is concerned, or well, we have been exercising rights in our area. Corporation has never exercised.
Mike.
This is a dispute between two public bodies, not a question of unauthorized construction or any such thing. Only that whether this area falls within the limits of Gram Panchayat or the municipal corporation. Because the High Court has not.
Your senior suit schedule.
Yes.
Just
Yes.
para.
Then it is
Entire village, east, this, west, this is covered by village.
Oh, it is like Asumeri abhi. जहाँ तक घोड़ा जाएगा ग्राम पंचायत. Yes, heard. Reserved for order. Reserved for order.
May I make a request? If your lordships are not with me, then in that case, your lordships kindly request the government to resolve this issue.
We are not adding a single word. No observation, no liberty, no clarification.
The government
will be done as it is. A single line by us would take 30 years to conclude this litigation. Yes, next.
May I only make one submission?
One more submission, just one more, Mr. Varma.
Yes, sure.
That it was Malad contended that this during after your lordship passed the status quo order. Some
No, we
Malad
may allow
people have,
SLP also.
some people have
We may allow also.
violated
But
that status quo order. I am saying
if we dismiss it, no
the
single word.
no collector's report. Malad pass appropriate orders regarding those people who have violated the status quo order.
That is what I
Collector
was
report is
submitting.
197 to out of 197, 77 constructions, the status quo order has been violated. I am not Mulad for them. I'm not Mulad. I don't Mulad support Mulad their case. You lodge may pass appropriate order.
Your Lordships, for a moment may see that 22nd January order once again, para 4. I was directed to file a compliance report of the collector.
We will simply close the contempt proceedings by saying that if there is any illegal construction, they will take it in accordance with law.
Yes. Massive construction.
See,
And Milord, one of the reasons why corporation is pursuing it serious, apart from reservation.
any further inquiry in contempt proceeding would keep this SLP also pending for number of years.
Yes, yes.
So instead of proceeding further in the contempt, we will simply close it.
Very well.
You lodge may, with regard to that, you lodge may pass appropriate orders.
One of the reasons why
Nothing to say
government-
about that.
With regard
Regarding
to
the
all
violation of
proceedings,
state-
we will pass appropriate.
Regarding violation of status quo orders, Mulad, I have nothing to say.
No, the appropriate authority will take.
Very well.
In accordance with that, as I said.
Very well.
Only one thing, Milord, apart from Milord, that bus terminal, truck terminus, etc., many of the bungalows are constructed in blue line, which is causing serious flood. Yes, Milord.
You will take.
Serious flood problems are one of the reasons for Milord is this. And Milord, the bungalow people are dominating the village panchayat who are Milord, who have set up this. They are struggling to demolish this for last Milord 13 years.
The roads are blocked. It has come on the road, the buildings, commercial buildings.
There is a legal construction in between 14 to 18. Prior to
For one of the implicit applicants. I want to say that their application for enumeration of illegal order have been rejected by the municipal corporation. That should not be reopened.
There is no question of, we are not applied to corporation. That kind
He
of.
says corporation, Mr. Duck has no
Yes,
right. He is all panchayat.
Gram
Petitioner one, number one, has right to decide what petitioner number two has
See,
done.
you are unnecessarily doubting him. He is a bona fide Gram Panchayat. He says that I will remove the illegal construction. But instead of corporation, allow me to remove all the encroachments, all the illegal construction. You are unnecessarily doubting
Yes,
it.
yes, looks like that. Looks like that.
But
Please, Mulad, please kindly bear in mind that this, they have applied for the permission, they were granted permission for the construction. Very well.
Yes, thank you.
Grateful to you.
Grateful.
My lord, in item 20, I appear for the respondents. I have filed my wakalat day before yesterday. Please grant me some time for filing counter affidavit.
Item 20.
Respondent number 4 was not served, but I have filed wakalat even on behalf of her. So all respondents are now before my lord.
Just 2 weeks for counter.
3 weeks, my lord, they have vernacular language.
Weeks for counter.
Obliging.
There is only one request, Milord, in item 20, item 19. Milord, in my case, there are some problems coming in, Milord. Your Lordship may allow the physical appearance to be given, Milord. My AOR, Milord, has, Milord, she is inaccessible, so your Lordship may just allow. I'm so.
Yes. Yes. Yes.
Very short question. I'll just pass on a list of dates. किधर है अपना list of dates? इसको देने के लिए बोलो. Please pass. इसको देने के लिए विशाल के पास है. Lords, I am a judgment debtor in a suit filed by R2. In a money suit filed by R2, I was decreed ex parte and execution proceedings were initiated, my lords. In that, my lords may see at serial number 6 at 28/6/2013.
You are a judgment debtor.
I'm a judgment debtor. Auction sale was conducted, and R1 here, who is the auction purchaser, he purchased the property for an auction price of 10,60,000. He made a deposit of 25% also on the same day. That is around rupees 2,65,000. My lords may see at serial number 7 on the very next day, 29/6/2013, I made an application under Order 21 Rule 89 to set aside the sale. But I did not make the deposits that are required under Order 89, Order 21 Rule 89, that is to satisfy the decree and to deposit 5% of the purchase price to the auction purchaser on that day, my lords. Now on 1/7/2013, the auction purchaser also pays the remaining portion of the purchase price. On 27/8/2013 and on 3/9/2013, my lords, I filed 2 applications to grant me time to make the deposits required. And finally,
It was an ex parte decree.
Sorry, my lords?
Ex parte decree.
Ex parte decree. I join at the time of execution proceedings only. And finally, my lords, on 29/2013, I satisfy the decree directly to the decree holder, respondent number 2, and I also make a deposit of 5% of the purchase price, which should go towards the auction purchaser before the court below. Now, this deposit itself is on the 84th day. Though I had made the application on the very next day, I made the deposit on the 84th day.
Is the writing out of
60 days. Order 92, Rule 2. Now, there is a constitution bench judgment of this court. I will show that, my lords, as to whether the 60 days that is prescribed in Order 21, Rule 92 is a limitation to make the deposit. This court has held that no, it is not a limitation. The limitation is only as far as making the application is concerned.
Brother was asking you something.
Yes. Now, later on 25/9/2013, the auction purchaser also makes an application to confirm the sale, my lords. On 5/10/2013, that is after I had made the deposit, the execution court allows my application to grant time to make the deposit. On 11/10/2013, the execution court sets aside the sale and puts the property back to me. That is challenged by respondent number 1 before the High Court under Article 227. Now, the High Court holds that the period prescribed under Order 21 Rule 92(2) of making the deposit within 60 days, that is a hard limit. And if that deposit is not made within 60 days, then the court has no option but to set aside, but to confirm the sale.
Date from the date of auction.
60 days from the date of auction.
That is 28/6/2013.
Yes, 28/6/2013 is the date of the sale. I make the deposit on 29/2013. 20/09/2013.
You went and paid the decree holder directly?
I went and paid the decree holder directly.
And then property also brought to sale?
No. No, the property was
He was brought to sale to realize the decretal amount.
That's right, my lords.
When you are in the process of setting aside the sale,
yes,
you went and directly paid the decree holder the decree amount.
That's correct. That's correct. Now, under
the execution continued because of the time delay.
Because of the time delay.
So, even after satisfying the decree, the execution went on.
Even after, now, under Order 21 Rule 89, I have to make.
No, when did the decree holder inform the court about full satisfaction.
That's the point.
This is 20th 9.
20th 9.
209.
Yes.
11, serial number 11.
No, you only say, you're not informed it.
Informed. Decree holder who received it in full satisfaction. Is it recorded?
Yes,
Is
it
it
is
recorded
recorded.
in any order sheet?
Yes, yes. I'll show that.
Date, that is my brother's question. Which date was it recorded?
That was
Sir, page 29.
That was on 11/10/2013, my lords. 11/10/2013 is the order which sets aside the sale, where all these applications are considered together. That is at page 36 onwards, my lords. Annexure P5.
Setting aside the sale.
By setting aside the sale.
36.
Page 36 onwards, the operative portion would be at page 39, para 8 onwards, my lords.
And on that date, the sale was not confirmed.
That sale was not confirmed.
Sale was not confirmed in
No.
his favor.
In his favor.
Yes.
Please, my lords. At the outset,
If full satisfaction
please, my lords. No, no.
recorded
Ah,
by the executing court,
please, my lords.
and on that date, the sale was not confirmed.
Please, my lords.
So the sale can be confirmed at a later point of time.
Please, my lords. My lord, the
Full satisfaction was recorded.
please, my lord.
This is the only question.
Please, my lord. I'm to the point, my lords. Yeah. Please, my lord. My respectable first is this: whatever substantial question of law raised by the petitioner herein is not applicable to this case.
Substantial question of law
Is not applicable to this case.
Can to be a substantial question.
No, my lord.
What
Secondly,
the petitioner is raising.
please, my lord. It is their case that a fraud is committed. If there is a fraud,
Of the fraud, we are only on law.
please, my lord.
Fraud
On the
is a-
point of law, my lord, the issue raised by the petitioner herein is squarely covered by a judgment of this honorable court. That is a 5 judges bench court, my lords. And I have also.
They would also rely on this very same judgment.
Please, my lords.
You might say,
Yes.
when if expected recorded, if option is complete and you have not challenged in accordance with law,
I have, my lords. So therefore,
where you say that it's not, even if you're out of time, it is not a,
as far as making the deposit is concerned,
you have a judgment supporting this proposition that one degree holder has full satisfaction. Execution has to be closed.
right. Now, my lords, as far as the time for making the deposit is concerned, my lords, that there is a judgment of yes.
Just
I'm sorry.
tell us, page 36 onwards,
Right.
which page this satisfaction is recorded? Which paragraph?
Para 8, page 39. Regarding the decree debt, the judgment debtors have settled the case with the decree holder directly. The decree holder has issued a receipt showing receipt of rupees 5,12,881 from the judgment debtors towards full and final settlement of the claim. In my view, the judgment debtors, by paying the said amount to the decree holder directly in full and final settlement of the claim, have substantially complied with the mandate under Order 21, Rule 89, 1 of the CPC. The contrary contention cannot be accepted. Once it is found that the judgment debtors have complied with Order 21, Rule 89 of CPC, the conclusion that follows is that the sale is liable to be set aside. The prayer in EA 245 of 13 is liable to be granted. Once such a conclusion is arrived at, the prayer in EA 351 of 2013, that is their application, will have to be rejected. At the same time, it has to be ordered that the purchase money deposited by the auction purchaser, together with 5% of the purchase money deposited by the judgment debtor.
The missing line.
There is some missing lines, yes.
Not one. Maybe generally 2-3 lines are missing generously.
And
must be returned to the auction purchase.
Must be returned to the auction purchase.
What is
For
it?
the,
Can't guess it. Yes.
I'm sorry, my lords, I'm sorry. I'm sorry.
Original records नहीं आएगा.
Para 10 makes it clear, my lords, on the next page.
So once he is fully satisfied, double whammy हो गया. that this order or reasoning of the trial court
Yes.
that prior to confirmation, if decree holder is satisfied, even if your challenge is technically not correct since you are not deposited, till the execution has to be closed. Or you may say your challenge was
Yes.
within time.
Yes. The question is whether now the High Court finds.
Otherwise, the court
Yes.
can always say, pay you the excess money over and above the decreed amount what the auction purchase has. Otherwise, it will be unjust enrichment for him.
Right.
So you pay you back the property money. The sanctity of the auction is upheld.
Right.
What is the law?
Now, my lords may kindly read Order 21, Rule 89 once, and then we can go to the judgment, my lords. I'll pass along the judgment in any case.
Page 3 of the impugned judgment, that is there. Order 21, Rule 89.
Now, may I read, my lords? Application to set aside sale on deposit. Where immovable property has been sold in execution of a decree, any person claiming an interest in the property sold at the time of the sale or at the time of making the application or acting for or in interest of such person may apply to have the sale set aside on his depositing in court for payment to the purchaser a sum equal to 5% of the purchase money, and for payment to the decree holder the amount specified in the proclamation of sale as that for the recovery of which the sale was ordered, less any amount which may, since the date of such proclamation for sale, have been received by the decree holder. Now, when a person applies under Rule 90 to set aside the sale of his immovable property, he shall not, unless he withdraws his application, be entitled to make or prosecute the application under this rule. Nothing in this rule shall relieve the judgment debtor from any liability he may be under in respect of costs and interest not covered. My lords may also see, which is where the time is prescribed, my lords. 92 says, sale when to become absolute or be set aside. Where no application is made under Rule 8, where no application is made under Rule 89, Rule 90 or Rule 91, or where such application is made and disallowed, the court shall make an order confirming the sale and thereupon the sale shall become absolute. Provided that where any property is sold in execution of a decree pending the final disposal of any claim to or any objection to the attachment of such property, the court shall not confirm such sale until the final disposal of such claim or objection. Now, two is what we are concerned with. Where such application is made and allowed, and where in the case of an application under Rule 89, the deposit required by that rule is made within 60 days from the date of sale, or in cases where the amount deposit under Rule 89 is found to be deficient owing to any clerical or arithmetical mistake on part of the depositor, and such deficiency has been made good within such time as may be fixed by the court shall make an order setting aside such a sale. Provided that no order shall be made unless notice of the application has been given to all persons affected thereby. Provided further that the deposit under this rule may be made within 60 days in all such cases where the period of 30 days within which the deposit has to be made has not expired before the commencement of CPC Amendment Act 2002. Now, my lords, earlier it was 30 days, and the limitation to make the application under Rule 89 is under Article 127 of the Limitation Act. 127, my lords. Now, since before this amendment in 92-2, there was a question whether the deposit could have been made after 30 days. That has been dealt with in the judgment that I have passed along, my lords.
What is the name of this?
This is Dadi Jagannatham versus Jammulu Ramulu, 2001 7 SEC 71. I would like to read 5 paragraphs starting from para 14. Lord, say para 14, may I start? Yes.
5 days bench.
I'm sorry, Mara. Para 14, 1-4.
में क्यों गया ये?
May I read, my lords?
Reference होगा ये.
14.
14.
14 to 19 is what I would like to read, my lords. If the rationale in PK Unni case is accepted, there is a manifest contradiction. As seen, the object and intention in amending Article 127 of the Limitation Act was to extend time to make deposit. This will not have been achieved if the rationale in PK Unni case is accepted. If Order 21 Rule 92 to CPC and Article 127 of the Limitation Act operate in different fields, then it would imply that the legislature had undergone a useless formality in extending the period of limitation to file an application. Order 21 Rule 89 CPC provides that an application to set aside sale can be made if the amounts therein mentioned therein are deposited. Thus, the deposit has to precede or be made at the same time as the application. There would be no purpose in permitting filing of an application after 30 days if the deposit had to be made within 30 days and the legislature would have undertaken a useless formality. A plain reading of Order 21 Rule 92 CPC shows that the court could either dismiss an application or allow an application. Order 21 Rule 89 CPC prescribes no period either for making the application or for making the deposit. The Limitation Act also prescribes no period for making a deposit. However, Article 127 of the Limitation Act prescribes a period within which an application to set aside a sale should be made. Earlier, this was 30 days. Now it has been enhanced to 60 days. Unless there was a period prescribed for making a deposit, the time to make the deposit would be the same as that for making the application. This is so because if an application is made beyond the period of limitation, then a deposit made at that time or after that period would be of no use. Now, 16, I would emphasize. Normally, when the legislature wishes to prescribe a period for making a deposit, it does so by using the words to the effect, no deposit shall be made after so-and-so days, or a deposit shall be made within so-and-so days, or no application will be entertained unless a deposit is made within so-and-so days. Order 21 Rule 92 2 CPC does not use any such expressions. The relevant portion of Order 21 Rule 92 2 reads as follows. It's quoted then. Thus, Order 21 Rule 92 2 is only taking away discretion of the court to refuse to set aside the sale where an application is made and allowed, and the deposit has been made within 30 days from the date of sale. It is thus clear that Order 21 Rule 92 2 CPC is not prescribing any period of limitation within which a deposit has to be made.
Against you. This implies that the time for making the application, time for making deposit. So if 30 becomes 60, 60 is the time for making deposit because you can't make the application without the deposit, or you can't make the deposit beyond the time stipulated for filing the application.
This is answered in the
para 17 and 18. Procedure for extending time as you have resorted
this. No, this is answered in para 17 and 18. Viewed in this context, the intention of the legislature in extending the period under Article 127 of the Limitation Act may be seen. It is very clear from the statement of objects and reasons which have been set out here and above that the period under Article 127 of the Limitation Act was extended from 30 days to 60 days in order to give more time to persons to make deposits. The legislature has noted that the period of 30 days from the date of sale was too short and often caused hardships because judgment debtors usually fail to arrange money within that period. The question then would be whether by merely amending Article 127 of the Limitation Act, the legislature has achieved the object for which it increased the period of limitation to file an application to set aside sale. Having given our careful consideration to the question, we are of the opinion that there is no anomaly and that there are no different periods of limitation for making deposits and or filing an application for setting aside the sale. It is by virtue of Order 21 Rule 89 CPC that an application for setting aside a sale and a deposit can be made. Order 21 Rule 89 CPC does not prescribe any period within which the application is to be made or a deposit is to be made. All that Order 21 Rule 92 2 provides is that if the deposit is made within 30 days from the date of sale and an application is filed, then the court would have no discretion but to set aside the sale. That does not mean that if the deposit is made after 30 days, the court could not entertain the application. If the deposit is made beyond the 30 days but within the period of 60 days, then it will be within the discretion of the court whether or not to grant the application.
Now 60 days is coming now.
But this was in a situation where there was the period under.
Only question is whether
the court has
deposit
discretion.
Whether a deposit will be a valid compliance, lawful compliance of 2192,
92.2.
Payment directly to the decree holder is the
It is a substituted satisfaction of the decree.
because
Now,
it was well within 60 days.
It's not strictly under,
Was it within 60 days?
not within 60 days.
Within 60 days.
On the 84th
Problem.
day, 24 days delay.
Problem is that.
Yes.
You have to answer that.
So it is within 90
The
days.
question, my lords, according to me, my lords, the question is whether when an application has been made within 60
Who is
days,
in possession?
I am in possession. It is my house.
Where is the auction money lying from?
It's in court. The
5% around.
No, the 5% and also the purchase price paid by the,
Was paid by him.
yes.
Is it lying in fixed deposit?
Yes. Now that has been allowed to be withdrawn by the execution court.
By him?
By him.
When did he withdraw?
He has not withdrawn it. He challenged that, and that under our,
FT or is it lying in treasury?
it might, that I am not very sure, my lords.
That's just going to pass.
But when I have made the application within time. The application itself is within time, but the
You are not in possession.
I'm not in possession, my lords.
Take some additional amount you take and then leave it.
Auction purchase, you must have bid several auction purchases.
My lord, my most respectful submission is that the conclusion of the High Court. I'm just reading that, my lords. The impugned judgment, page 11, para 19. Can I read it, my lords? Because it is loud and clear. They have to make the deposit within 60 days time. Secondly, it is their case that a fraud was committed. That was never pleaded or established. But I purchased this property at a price almost 4 times than the relevant price at the time of the relevant time, my lords. So once these 5 judges bench, my lords, plot, my lords.
house plot, my lords.
House, it's a residential house.
Yes, yes. It's 13.4 acres or 33.116.
Living there.
I am living there, yes.
So can I read just page 11, para 19, my lords? The operative portion of the High Court judgment.
How much additional amount will satisfy you?
My lords,
Medicinal, some law apart.
but I will take instructions, my lord, on that. But otherwise, can I say something on the point of law?
Yes.
That is page 11, para number 19 of the impugned judgment.
11 para 19.
19.
Letter of law, spirit of law, justice.
Please, my lords. Please, my lords. Balance all the 3, please, my lords.
Come back at 2.
Please, my lords.
Not got possession.
Please, my lords.
Residential property.
Please, my lords.
Is gone and paid the decree holder, whether cleverly or we don't know. There's a delay in deposit also.
Please, my lord. It was not in my 84th day. Otherwise, it.
Right.
Please, my lords.
I've invested money that's lying in deposit.
Please, my lords.
That, when did you deposit the money?
Because that was immediate. I think it was.
2013.
It was in 2013. 28/6/2013.
You will get back that. And we'll ask
Property you may not get, but some additional amount.
additional amount.
Can I read this, my lord? Only because
Yes, we
page
have
11, para number 19.
Going into their property and throwing out their family.
Please, my lords. Anyway, I will take instructions. And before only I want to share my thoughts on this, the thoughts of the Honorable High Court.
Yes, we'll allow you to argue.
Please, my lords. I will, please, my lords.
But seek instructions. If
I will
it
take
is ready,
instructions, please, my lords.
then probably, but since You have prepared the case, you have to argue.
Please, my lords.
Oh.
Please, my lords. Page 11, para 19.
Page 11, para 19 of the impugned order.
Impugned judgment. Para 19. The conclusion is this. Under Order 21, Rule 89 of the Code of Civil Procedure, the person interested in the property sold the auction should deposit in court and not elsewhere the amount required to be deposited by him under rule within 60 days of the sale before he can file an application. That is, it is a mandatory requirement before filing the application, which need not be any particular form, for which also the period prescribed by law is 60 days from the date of sale. But if the party satisfy the court that the decree was otherwise fully satisfied before the application was filed and not later, it need not insist on deposit of the amount due to the decree holder in court. The court has no right to extend the time either for depositing the amount or filing application to set aside the sale. An application filed without complying with Rule 89 or Rule 92, 2, Order 21 of the Code of Civil Procedure Code, beyond the prescribed period of limitation, Article 127 of the Limitation Act is liable to be dismissed in limine. The judgment debtor cannot maintain an application under Rule 89 and 90 simultaneously. Judgment debtor's non-compliance with the Order 21, Rule 89 of the Code of Civil Procedure entitle the auction purchaser to get the sale in his favor confirmed. The impugned order is best with illegality. In result, the original petition is allowed, the impugned orders are set aside, and rest of the proceedings. At the same time, I may be permitted to see that Annexure P4, page 34. That is before the execution court. Page 34 and 35. It is not even a speaking order. It is just say heard aloud. That is at page number 35. So, it is not, on that date also I was not heard also. After all, I am an auction purchaser. So, because this is not a speaking order. It was not supposed to be listed on that date also. That is evident from the B diary. That is page number 13.
What was this application? Page 35? Early hearing.
No, my lords.
Grant time to make the deposit. My application to grant time to make the deposit. This was heard and allowed on 5/10/13, but I had already made the deposit on 29.
This was an application by you.
Yes. Grant further time to make the deposit and to comply with Order 21, Rule 89.
Where is this IA?
That IA has not been placed on record, my lords, but the IA numbers is EA
was on 5th of October.
5th of October.
5th of October.
Yes.
That was after 60 days.
Yes, but I had already made the deposit on, paid the auction purchaser and made the deposit on 29/2013, my lords.
That is also after 60 days.
After 60 days, after 60 days. But not an inordinate delay in any case, only 24 days of delay.
Your IA seeking extension was also beyond 60 days. When the period is over, and that is the period provided in CPC, how can an IA be allowed?
No, the IA,
to
two
seek
IAs were
extension
made
of the period.
Realize the significance of this question.
Yes, I understand, my lord.
148, 149, etc. will not come to your aid.
Now, the IAs were made, two IAs were made, one to satisfy the decree and another to grant time to make 5% of the deposit. Those applications were made on 27/8/2013 and 3/9/2013, my lords. That's serial number 9 and 10 I have mentioned in the list of dates. Those are the applications. And on 29/2013, I pay the decree holder in full, and I also make the deposit of the 5% purchase price. And it is thereafter that this order is passed, 5/10/2013, my lords.
You see, on the very next day, 29th June, you moved this application
Yes, I did.
for setting aside the sale.
Yes. Now I was running here and there to raise the funds, my lords. As soon as I could raise the funds, I made the deposit. There is no
What
inordinate
was
delay.
this IA, what was stated? You will,
It is fixed and granted by the.
Four days, my lords. It's not inordinate by any
48 CPC won't come to your aid.
Right.
So there it has to be fixed by the court, is it? Have you checked up?
have you checked up? What,
I'll go through that and answer, my lords.
what brother is saying,
I think
that
prima
if
facie it looks-
if the court has allowed you,
Yes.
probably that may save you. And that may extend the limitation.
Yes,
Where
it was
any
allowed by P4, my lords.
Hmm?
It was allowed by P4.
P4, page 35, it
Yes.
is allowed.
Yes.
But you check 148, 149 CPC,
Yes.
whether court can extend the period of limitation which is provided in CPC.
That is answered in the
48 says if the
That
court
is
has fixed the time, court can extend. But if the court has not fixed the time, but the CPC has fixed the time, whether court can extend the time fixed by the CPC.
As far as 92(2) is concerned, that is answered in the Constitution
like
bench, my
a
lords.
case where proceeding 30 became 60.
No, 30
2002.
becomes 60 after this judgment, my lords. This judgment is 2001. The amendment to 92(2) comes in 2002, my lords.
Why did they deal with 60? Because of limitation.
Because there was an amendment in the Limitation Act
When did that amendment come?
to enable the judgment.
When did that amendment come?
That is an amendment to Article 127, my lords.
Which year it came?
Just a second. That came in 1977, my lords.
When was what are the facts in the Constitution bench?
In the Constitution bench, what happened was that the deposit was made on the 59th day.
Exactly what I told you.
Yes.
Limitation amendment came pending the proceedings. Give me the facts. Probably 80 is the decree, is it?
Para 3 and 4, my lords. On 25 of this judgment, on 25 to 1980, a decree was obtained in a suit based on a promissory note executed on 21/1/1972. That decree was put into execution and the property of the judgment debtor was attached and put up for sale. The sale was held on 22/11/1982. On 21/1/1983, that is on the 59th day after the date of the sale, an application was filed under Order 21 Rule 89 CPC and the prescribed amount was also deposited.
So the Order 89 said 30 days. 92(2) said 30 days.
At that point,
127 said
60 days.
So they said 60 benefit is available.
60 benefit is available. And what the court has concluded at para 18 is the period prescribed in 92(2) is not a limitation to make the deposit.
But 127 is.
120, that is to make the application, my lords. The application has been made within 60 days.
Both has to be done within that time. Very clear.
My lords may see what is.
So what according to you can deposit anytime?
No, then there is a discretion that is, see, what the court has held is, if the deposit is made within time, then the court has no discretion but to set aside the sale.
Notwithstanding 92(2) saying 30 at that time, they have made it 60 because of 127.
I'm trying to respond.
Where is the law beyond 60?
I'm trying to respond, my lords. What the court has held according to me is, and I can take my lords through the relevant paras again. If the deposit was made within time, that is within 60 days, then the court would have no discretion but to set aside the sale.
Yes.
Therefore, if a deposit is made beyond the period of 60 days, then the court has a discretion to allow it. That is stated in para 18, my lords. May I just
60 days.
Beyond 60 days.
Let us read it.
Now, in this, it is said beyond 30 days, but within 60 days. But that was because of this anomaly, this apparent anomaly, my lords. Para 18. Having given our careful consideration to the question, we are of the opinion that there is no anomaly and there are no different periods of limitation.
Yeah, it is that. That does not mean.
That does not mean
does
that
not
if the
mean
deposit
that
is
if
made
the
after
deposit is
30
made
days,
after 30 days,
the court could not entertain the application.
Not
If the
entertain.
deposit is made beyond the period of 30 days, but within the period of
60 days.
but that was because there was this apparent anomaly, my lords. I would say that this reasoning can be extended beyond.
No, then it will again be. It is in your favor.
Yes, exactly.
If the deposit is made beyond the period of 30 days, but within the period of 60 days, then it will be within the discretion of the court
whether or
not to grant the application. The word then it will again.
Next line, thus an application can be made within the period prescribed under 127. An application can be made within 60 days. No period for making deposit prescribed under 21. The deposit can be made within 60 days.
Can be made.
Can also be
does
made.
Not say cannot be made after. That's what I would.
And also, what does it mean otherwise?
No, it's something which is to save the judgment debtor because of this. It's left. Yes,
if the court has the discretion, then it may be 100 days, 200 days.
But here only 24 days.
300 days.
Here only 24 days.
First, we have to decide on law.
That's right. That's right.
Permissible
that's
on
right. That's right.
If permissible, then court can exercise jurisdiction or discretion in a given case.
That my lords may set an outer
days or 600 days.
That my lords may set an outer limit if required.
Confirmation is also due, no? It's also
Yes.
waiting for confirmation, so it has to be done within that time.
Yes.
Then
I understand, my lords. My lords may.
If went and pay the decree holder, clause B says 92(2).
Huh.
Could have even deposited in court.
But in any
Now there are judgments
Deposit. Under the proclamation.
that is 84. Rule 84 is what prescribed.
Harmonize it.
May I mention, I'm extremely sorry, my lord. May I mention item 102, my lords. It's a matter, Daryaganj matter, mean profit matter. It was heard, my lord, in different combination, Honorable NV Anjaria, my lord.
What do you want?
But sir, just next week, my lord. My Ranjit Senior Santosh.
102.
Yes, my lord, please.
The two adjoining lands.
My lord.
Two adjoining.
My lord, my lord.
Yes.
My lord. Next week, my lord, 26, my lord.
Means profit only, no?
My lord, please. My lord, please.
Next week.
Yes, 26, my
Read date.
lord. My lord, much obliged.
Please, my
That
lords.
item 15, your lordships kept it at 2 minutes.
My lords, I'm mentioning item 27, my lords. My lords, a notice was issued, but there was difficulty in filing the appearance online, my lords. So I'm requesting my lords to.
Which matter?
Item 27, my lords.
What do you want?
Physical appearance may be permitted. Grateful, my lords.
Please, my lord, in item 15, my lord, my client has agreed, my lord, to give visitation right every month. Every day, if he willing to call child, my lord, he is free to do so. And that clause has been removed, my lord, where muscles and all these things. Because this is their second marriage, my lord, and now they want various litigations where there, my lord.
No,
want to
not
settle
my
everything.
second marriage. She's. But anyways, my lords, I'm ready.
So, my lord, I have corrected. If my lord may want to place it on record, otherwise, my lord, may correct. Yes, my lord. My parties are here, my lord. Parties are here. My client is here. May I call her? She is here, my lord. My lord, I have corrected, my lord. In page 19, my lord. Para E. Given that every day if he willing to have a call with child, my lord, and every month if he wants to visit, no problem from our side, my lord. We will full cooperate. Even she was saying that if he want to meet on parents meeting or any official functions, we have no problem.
Important. When they see
Like
other
she is
children
agreeable.
coming with father.
Yes.
And in this case not coming, he will ask.
Yes, my lord. What she was saying to me, my lord, she says that if we want to have a attend any functions of the college or any official function of the college, she has no problem at all, my lord.
Which part you have corrected?
My lord, I have corrected, my lord.
Lords, lordship may E. Only E, my lords. E.
E, and there was one more correction.
Entire E is corrected or some part of it?
No, my lord.
Part, my lords.
Second part, my lord. Page, your lordship, page 19 may see original. I did corrected, my lord. Corrected, matlab I have added that every month. May I read, my lord, that portion?
Yes.
My lord, as such a, my lord, however, the first party shall have visited right to meet his minor son, master, Anmol once every month, my lord. It is there. And after, my lord, 5-6 lines, my lord, I have written that further the first party shall entitled to speak with the minor child telephonically once every day at a material convenient time, my lord. And that portion, my lord, where your lordship was saying that I have removed that part completely, my lord. At page 20 in original.
Appreciate her. We appreciate her stand.
Yes, my lord. She is ready to cooperate.
One word from your lordships has done everything. Lords,
Yes,
we have
ma'am.
tried it. And lordship, this is a lords, very unfortunate. 4 times mediation failed. No, everything. Now, lords, we have done it, lords, so we again, lords.
This has been signed by all the parties?
Yes, my lord.
Yes, my lords. Now, lords,
Proposal was signed by all parties, my lord. But 3 pages we will get it signed.
Press one.
Yes, my lord, we will get it signed. Parties are here.
Sign it. Just correct. You do it here.
Every page, my lord. Simple.
How old is his son now?
Son, my lord, 9 years old, my lord, and he is studying in one of the best college in Calcutta, my lord. He is studying in Calcutta.
Calcutta.
St. James. Yes, my lord. St. James, my lord.
This was pursuant to mediation or they have
we have,
my lord, mediation failed.
We have tried, lords.
And
before have succeeded, mediation failed.
Yes, my lord.
Sometimes, lords.
Mediation failed, then it was listed before another bench, my lord. That bench has asked us to sit again and have a mediation. Even last time, your lordship has directed us.
On the last date, my lords, short time, lords. So, lordship.
Even last time, your lordship has directed us, my lord, to.
Take.
And in my lord, in for payment, my lord, today he is paying 1.5.
Petition or 2 petition? Transfer petition?
Yes, my lord. Only one transfer petition is there.
Dependency of this.
सबको पूरा देना पड़ेगा पैसा पूरा देना पड़ेगा ना इसके बाद
of money?
My lord,
18 minutes. Lordship, see page 18.
page 18, my lord. It is there. 90 days, my lord. First payment he is giving today, 1.5 crores, my lord. And for 2 other remaining payments, my lord, he will giving check to me, my lord.
Post-dated checks.
Yeah, post-dated check he is giving.
We keep
He will give, my lord.
We will keep it on the day when, see, under 142,
Yes, my lord.
we can grant divorce. We can't solemnize marriage.
Correct.
It is not given. So it has to be done after the last day, isn't it?
Last date is 19/5/26.
Subject to, my lord, the last payment, your lordship may grant this, my lord.
The divorce cannot be subjective.
See,
I
there are
will leave it to your
remarriage
lordship.
issues involved in between. So many issues are involved.
But only one prayer is there, my lord. Lordship may stay all the proceedings, my lord, in the meanwhile.
That can be done.
Yes, my lord.
But then in the meantime, we can keep it on 20th May or
My lord.
21st May. And then the order
Nice.
can be.
Both parties have signed, my lord.
Witnesses.
It's for opinion.
It's in the court. Please have referred joint application under Article 142 of the Constitution of India for recording the terms of settlement and for passing an order in accordance thereof. The matter was taken up for hearing in the pre-lunch session. This court pointed out to clause E of the terms of settlement, clause E, which is this paragraph. Clause E, capital E of the terms of settlement.
Page 19, my lord.
And pursuant thereto, the parties have placed before us a fresh terms of settlement substituting the earlier clause E with a new clause and a fresh term duly signed by both the parties in the court itself has been placed has been shown to us, has been placed before us, and the said terms and the said fresh terms are made part of the record of the SLP. Full stop. Record means full stop. Para. Under the terms of settlement, this is incomplete, but I have started from clause A.
B is here, my lord.
Only
B is
that
here.
clause
That's
they have.
18, 19 and 23 pages, Lordship.
But some pages were coming in another, that's why.
Actually, you have to give fully.
Fully A to E.
Lord, we have given full, my lord. It is there, but not full all settlement.
It starts page 18.
Page 18, my lord, it is there. From divorce to, actually one line was missing, my lord. That's why we have added in 18. Your lordship has just see last line.
It should have started from clause A.
A,
capital
my
A
lord.
to
Correct. Your lordship is right, my lord. Your lordship is right.
A is incomplete. We should
Yes.
Let them give fully.
We will give it
fully.
We will give it, my lord.
Typed again.
Yes, my lord. I will type it again.
In the course of the day, we'll do it.
Abruptly it starts.
Yes, my lord. We will give it to court master, my
So
lord.
that we have recorded
Yes,
that
my
fresh
lord.
terms are.
It was our mistake, my lord. It was our mistake, my lord.
They are here, take benefit of their presence and
Please, my lord.
system. Under the terms of settlement, under clause B of the terms of settlement, the first party with bracket husband is required to pay the sum of rupees 2.75 crores to the second party bracket wife in 3 installments, the last of which falls on 19/5/2026. Since a decree for divorce by mutual consent is to be granted upon full payment of the amount, we are of the opinion that the present IA should be considered after 19/5/2026. Accordingly, post the matter on 19 के बाद तो working है,
25 को ऐसे
25 भी है, 21st
उनके टाइम पे आपकी क्या गया है
handing over that demand draft, the first installment minutes today.
Installment
Audit minutes and
yes.
there in the terms.
No, my lord, DD's details are not there, my lord. Only they give that at the time of hearing they will give.
in terms of the settlement minutes today on or before 1.5. So today minutes I'm other 2 minutes.
You have handed over demand draft?
Yes, minutes. These are the copies.
The last of which falls on 26/5 and 19/5/2026.
What is the date of this demand draft? 2nd February. ठीक है.
The demand draft for rupees 1.5 crore.
12.
Get
2nd February.
12th minutes, 12th, 1-2. Yes.
February 2026 has been handed over to the petitioner oblique second party bracket wife in the court itself. And she has acknowledged the receipt thereof.
Lord, entire proceedings may kindly be stayed, my lord. In terms page we have mentioned everything, my lord.
Lordship may stay,
Of the settlement.
Please. Page 10 in our application.
All
Page 10 and 11.
Between the parties shall remain stayed
Please, my lord.
till the next date of hearing.
Highly appreciate.
In the course of the day, we will hand it over to the court master.
Yes.
That settlement.
Yes.
Yes, my lord. We will give within an hour, my lord. Before your lordship rise.
Which parties are here, they'll sign it.
Ask your client to avail the full.
Yes, everywhere.
Go for PTM everywhere.
Highly obliged, my lord. Because of your lordship last order, my lord, we did our.
Yes.
We short time, somehow.
No, it is so good. We will record your appreciation.
And both of us.
Full encashment.
And both of us, we're worrying about this clause, which your lordships, of course,
Yes, my lord.
but since your lordships, put something, now, everything is
Now
streamlined.
imagine if he
I understand,
when he attains majority and goes through this.
Understand,
What will be his?
At times, something
Correct, my lord, correct.
which are not in our hands, we cannot be.
You are right, my lord.
We repeatedly tell our.
Even if that clause is removed, don't bring any muscleman.
No. Actually, he is disabled, so he needs somebody. That's the thing.
Correct. Highly obliged.
We are happy.
Yes, my lord. We will give a place to court master, my lord. Please, my lord.
Another happiness if he agrees. Yes,
My lords, I took
possibility.
instructions. I was informed that they sold the said property more than 12 years back. That is Annexer R4. He sold the property. They are in Bangalore and his son is settled in Canada.
Son is settled in Canada.
If the record is there.
Auction property possession was with him.
About the auction, but they are in Bangalore. That is my instruction. But they said that they have got a building.
He was in possession.
No, he sold it.
Because
he has sold it.
He has sold.
So anyway, it's even more. You should take some money and go.
He is not there, my lords. Because there are two things, my lord. If it was on the point of justice.
Since now it is in possession of another party who is not a party to this litigation,
Please, my lords.
will be in further difficulty.
No, I am not talking about my property, my lord. They say that they are staying there. That was a wrong statement.
This subject property, not your property.
No, my lord.
Subject property, you are not in possession. They are in possession.
Please, my lords.
They have sold it to
No, that they have not sold it or not, no idea. Only they can say, my lord.
that they have sold it.
No,
They have moved out of the area.
Another area, because just adjacent to this property, there was a plot of land where they were staying, and they said that they were staying
He
here.
said that they are living in the subject property.
No, my lord, that is incorrect.
That's what I was instructed. I can take further instructions if required, my lords.
Or what about the suggestion by the court that you take some more amount and then
My lord, I have taken this property more than 5 times the market fair value, my lords. At that time, I have taken in that way like this.
That you will get back. That money, 5 lakhs with interest, you will get back.
10 lakhs.
10 lakhs.
More also.
But it is more than 13 years, my lord.
10 lakhs.
13 years.
10 was the sale price, my lords.
10 lakhs. So something more has to be given.
Hmm?
If you want to preserve the property is appreciated now.
That is the reason, my lords.
tomorrow?
Tomorrow, this bench may not be.
We are in the same
Yes, then
combination.
morning we are there.
Very well.
In the first half, we are there in the
Very
same
well.
combination.
I'll take instructions and come back.
And this is not a, this is a regular method. Okay. Till 1 we are here.
You want to mediate and then we can do that also.
If it falls for my lords, then it can be tried, my lords. I will not oppose any.
Lords, I'm totally agreeable for mediation, no doubt about it.
So that the entire terms is not talked about in the court. In what terms you will settle eventually. That will be more freely discussed before the mediator.
On fair principles, because I purchased it. That's if it was a dwelling house, no doubt.
Here.
They were in an upper hand.
Here or in Kerala? From Kerala or Karnataka?
Kerala.
From Kerala.
Where?
That is near to Kottayam, my lords.
So you want mediation in Supreme Court or in Kerala High Court?
No, even here itself, my lord.
Here itself.
Kerala High. Yes, either way, my lords. I
will do it here.
My understanding, he is in Bangalore, and my client is, of course, in there itself.
Considering the nature of controversy involved, we deem it appropriate to refer the parties to mediation in the Supreme Court mediation to be conducted by the Supreme Court. The parties shall appear before the mediator through virtual mode on when? After Holy vacation or what?
After Holy vacations.
On 10th, on 9th of March.
Please, my lord.
And thereafter, they shall appear either physically or virtually as directed by the mediator.
Please, my lords.
Post on 22nd April.
Very well, my lords.
Along with mediator's report.
Maybe the best course, my lords.
Yes. Something will work out.
Yes. I'm grateful, my lords.
I'm highly obliged.
Please, Your Lordship. Your Lordship has appeared in this matter in the admission
yes,
stage.
yes.
I would
This one?
Yes, this
request
was
Your Lordship.
Post after 2 weeks for a bench in which one of us, the economic,
Obliged, Your Lordship.
302 matter.
Lordship, may I just pass on the submissions we prepared? We prepared short submissions in this matter and a compilation of the judgments. Just a second. Give me a second for the other side also. Submissions.
Lordship, this is that matter where the accused is absconding for last 12 years, Lordship. Lordships had said that Lordships will hear it despite convict. I'm sorry, Lordship.
The petitioner, Your Lordship, is being convicted under 498A and 302 for the same evidence. Originally, the father, mother, brother, and the petitioner were charged. At the trial stage, At the trial stage, the father was acquitted. The mother and brother have been acquitted by the High Court. And
4 accused initially.
originally, yes. The trial stage, the father was acquitted.
Petitioner is the husband.
Petitioner is the husband. It's a case of dwelling house. The body was found hanging in the room where the petitioner and the wife used to stay.
Lordship may also have the original records, Lordship.
The original records are here.
Other 3 accused are the father, mother, and
Father, mother, brother, and the petitioner, the husband, were originally charged, acquitted. The father was acquitted by the trial court. I mentioned the details in para 2, Your Lordship. The mother and the brother have been acquitted on the same evidence by the High Court. The death has taken place about 1 year after the marriage. The FIR was lodged by the father of the deceased. There were a total of 15 prosecution witnesses. The defense didn't lead any evidence. There were a total of exhibits of 15 documents. There were 313 statements which were recorded. Substantially, Your Lordship, there are 3 categories of witnesses. One set of witnesses which testify to the effect that there were allegations of dowry and harassment to the girl. Out of the 15 witnesses, Your Lordship, about 6 witnesses have turned hostile. The second set of testimonies are with respect to who had seen. There's no eyewitness to this, but there were 2 witnesses, out of which one is turned hostile, who had claimed that they saw her hanging. I'll take Your Lordship through the testimonies of these witnesses also. The last and the most crucial witness and testimonies will be with respect to the medical evidence.
All 4 were inside house at the time of offense.
No, Your Lordship. It was the husband's specific house which they found her in.
Others were not.
There seems to be a separate room oblique house with respect to the others. I'll show Your Lordship the
Therefore,
sketch.
106 has been applied only
Yes,
for
Your
husband.
Yes, Your Lordship.
And others have been let
Yes,
out.
Your Lordship. So I'll take Your Lordship to the judgments with respect to 106 also. A hammer was seized in this case, and the post-mortem report would indicate that there were certain injuries and it's a case of homicidal hanging.
No ligature mark also. PW 13 speaks.
Yes, Your Lordship.
Head injury.
Head injury is indicated in the post-mortem report, confirmed by the doctor's testimony also. However, Your Lordship, the doctor also indicates that it's an injury caused by the hammer, and there was nothing which is otherwise connecting the hammer to the injury. The forensic evidence, there is no forensic evidence with respect to the hammer. No fingerprints, no blood marks, nothing.
Hammer is recovered from the house.
It's seized from the house. The seizure witness only says that they've just shown me the hammer, nothing else.
Stains.
No blood stains. And the
Blood stain means, was it an internal injury or a laceration?
it's a deep wound on the scalp. It could have been, the doctor himself says it could also happen in case she falls or falls.
Whether he's asking about whether it was an external injury also and blood was oozing out so that blood would come in the hammer,
blood oozing out,
or
Your
it
Lordship.
was
There was no blood oozing out. In fact, the people who saw, they just saw 2 injury marks on
absence
the...
of blood is not significant. That is what.
I'm sorry, I didn't get the last.
No,
Okay,
if,
so?
the blood is not oozing out,
no.
Hammer can cause a
Concussion, which is
concussion, internal injury, which may not,
be seen.
Blood
This
in
is the finding, internal hemorrhage is the finding, Lordship.
The High Court, Your Lordship, has gone through the testimonies of all the requisite.
PW1, 2 and 5. They are hostile.
Yes, Your Lordship. The first set of witnesses, if Your Lordship will take the note also, from PW7 to PW5.
They spoke against the rift between husband and wife.
Yes, Your Lordship. However, it may be pointed out, Your Lordship, that originally when they were making their statements, they mentioned that the entire family was involved and that in fact she was also being tortured by the mother and the brother, etc. Eventually, it is only the husband. They all changed their statements in their 164. Yes, I'll come to that.
Like 1 point, yes, correct.
The mercy is a sitting.
Yes, Your Lordship.
Even if he is absconding, the law is, we must decide
Yes,
on merit.
yes, Lordship. Yes.
Very grateful Your Lordship has given me this opportunity. There's one more very crucial aspect, Your Lordship. In fact, the time of death has not even been recorded in the post-mortem report. And one of the statement of one of the witnesses who's then found to be hostile, in fact, says that he saw her move when he saw her hanging on the on the ceiling. That has been disbelieved subsequently. That will be PW12. I'll take Your Lordship through his testimony. And PW12's final testimony doesn't record the husband to be in the room. He came in the house at 7 o'clock in the morning looking for a pen. When he entered the house, he found her hanging and he screamed, after which everybody else came.
Where was
the
night?
He was in an adjoining house, so it was an open house. It doesn't seem to suggest that the house was a locked house where only husband and wife were there. I can take Your Lordship first to the testimonies of the dowry witnesses who indicate that there's been harassment and torture by the entire family. They have subsequently only, a couple of them have subsequently only noted that it's the petitioner who's done it. But that itself, Your Lordship, will not take them to the next step, which is whether he did cause the murder. Should I take Your Lordship through the depositions, or would Your Lordship want to see the impugned judgment? They're both recorded in the impugned judgment also. The depositions for PW7 onwards starts at page 65.
Deposition weakness.
Yes, Your Lordship. Page 65, Your Lordship. I can take Your Lordship to 2-3 of such depositions because they all indicate that there was dowry and harassment involved. However, the role of the husband vis-a-vis the family is a little disputed. I've also, with the submission, annexed the original records of their 161 statement, which had indicated a larger role for the family.
If you highlighted the contradiction, we'll see it. Otherwise, how can we see that?
Yes, Your Lordship. Just let's show the family part, then we'll show that. Then I'll take Your Lordship to the ones who have found to be hostile.
65.
65 is PW7, Your Lordship. His 161 is not available. We can take Your Lordship to who are the people who have subsequently changed their stance. If Your Lordship will see PW1 at page 46. Okay, don't worry. His 161 statement, Your Lordship, I've just culled out from the record. I can also show it from the record, but I've got Your Lordship a copy at page 15 of the submissions. It's from the record only.
No, 161, we will not be able to see. If you
I'm only showing to show that
brought
how
up-
to change their stance from being the entire.
show it from the deposition.
From the deposition, Your Lordship,
This
they've
or the IO?
subsequently. So from the deposition, Your Lordship, the family has been noted by PW7. Father, mother, and the brother.
Generally,
Yes.
in the absence of those allegations, they would not have been made accused.
Correct, Your Lordship.
There has to be some allegation against them so that they are sent for trial.
Yes, Your Lordship.
So now, but in the court, the offense against them is not proved. Because basically court, it seems court applied 106.
106, sir.
106 would not apply to others, but only to the two inmates of the house, husband and wife. Even if there were allegations against them, that will not assist you
Very
because
well.
106,
Very well.
whether they were acquitted, there were allegations against them or which have not been proved later on, that is
Very
immaterial.
well, very well. So I will not labor on this aspect. Then I'll take Your Lordship straight away to two other categories of witnesses. One is Titan Das, Your Lordship, who was PW12 at page 89 and 91. This is only to complete the chain. If nobody has seen him in that room and it is an open room where anybody could walk in and go out, then the prosecution has not met the basic requirement of or the onus that was laid on them. At page 89, Your Lordship, the deposition of witness number 12 for the PW recorded and notes, so and so. I am reading at the bottom of paragraph. He's a neighbor, Your Lordship. He's a neighbor and he happened to visit the dwelling house at 7 o'clock in the morning. It will come from this. I know Gaur Acharji, who is my adjacent neighbor. Page 89, Your Lordship, the
Yes.
bottom paragraph. About 1.5 years back, one morning around 7 a.m., I went to his house to bring my pen. As I was searching the pen in the room of Gaur Acharji, I found the body of his wife Soma Acharji hanging from the ceiling in the partition portion of the room. Seeing this, I cried out and returned home. I did not see anybody else in the room. At this stage, the witness is declared hostile in the prayer of the prosecution as his deposition is contrary to the recorded statement and he's allowed to be cross-examined. I was questioned by the police, but I did not state to him anything more. Attention of the witness being drawn to the part of the recorded statement, witness denies that he made any statement to the effect that he saw Gaur Acharji lying in the bed, that he asked him to deliver the pen, and that thereafter seeing the body of his wife hanging, he asked and informed Gaur in this regard. The statements with the admitted portion, Exhibit 12, subject to the confirmation by the IO, I have come to the court with the accused. That's when I saw the body of, next page, Your Lordship, page 91. This is very important. When I saw the body of Soma Acharji hanging there, was still life in it because she was moving her hands and legs. This has not been dealt with by either of the courts. So he was the only person, Your Lordship, who saw the body hanging, supposedly with some life in it, and who did not see the petitioner, although I must admit here that in his 161 statement, he had said otherwise.
Actual correction, Lordship, just PW14 may also be seen.
PW14 is someone who enters the place after he hears PW12 scream. I'll take Your Lordship to PW14's testimony, which is at page 46. No, is it? PW14? 99, Your Lordship. Perry, I know all the four accused who are my neighbors. I also know Soma Acharji, wife of Gaur Acharji. Their relations were good after the marriage. She died about 1.5 years back. 2 days before the death of Soma, on return to my home in the evening, I asked her whether she had taken food when she stated that her mother-in-law did not give her food and she had taken food elsewhere. On the next evening, on return to my home, I found her sitting on the veranda. I heard alterations with hue and cry going on inside the house of Gaur. On that night, around 11 p.m. also, I saw her sitting on the veranda, and at about 1:30 a.m. that night, I heard her cries. The following morning, around 6:35 a.m., I heard cries of Soma saying Margot twice. After about 3/4 minutes, I heard cries of Titan immediately. I came out and asked Titan as to what had happened. He said that Soma had committed suicide immediately. I rushed to Gaur's room and found him lying on the bed with face downwards on a pillow. I found the body of Soma hanging from the ceiling. So it is after he hears Titan that he enters the house. seeing her in that condition, I looked downward and did not find any stool or anything like that. And I was wondering how she could hang herself. I then noticed that the body was hanging with a piece of sari, which I found mother of Gaur wearing previously. Thereafter, I called Gaur's parents from the Northern Biti room. After about an hour later, police arrived. Gaur, his mother, his father, Bimal Acharji, and brother Nitai Acharji were present today at the dock. And then when he's cross-examined, he says, police was there for about an hour and asked me about the incident. I narrated whatever I know. Altercation inside the room was going on between Gaur and his mother. I stated the police that I heard the cry of Soma at about 6:35 hours, but attention of the witness is being drawn to the relevant part of the recorded statement. This is not found. I stated to the police that about 3/4 minutes later, I heard the cries of Titan. But attention of witness is drawn to the recorded statement. This is not found. There was a case with the accused person relating to the boundary. It's not a fact that we still have enmity for the dispute. I stated to the police that I found Gaur lying on the bed with the face downwards, but attention of witness is drawn to the recorded statement and this is not found. It is not a fact that for previous enmity with the accused persons, I have deposed falsely against them as tutored by Soma's parents and by police. I did not state to the police that I saw Soma's body hanging with a piece of this sari at Gaur's, piece of the sari of Gaur's mother. I stated to the police that Soma informed me the previous evening that her mother-in-law did not give her meal that day. But attention of the witness being drawn to the recorded statement, it is not found. The witness is asked as to how he heard the cries of Soma Acharji at about 1:30 a.m. when he replies that he's a patient of asthma and cannot sleep properly. The rest of the witnesses, Your Lordship, are inquest witnesses and seizure witnesses. Anyone else in this category? No, then medical. So these are the so-called last scene witnesses, Your Lordship.
PW 14 is very clear. That he saw him lying on the bed face down.
Yes, Your Lordship, but by then Titan had already screamed. And Titan has not seen him in the room.
Titan says in the deposition, but he denies that he told the police that
Yes,
he saw him in the room.
Yes, Your Lordship.
But Titan saw the body. The
Body, in fact, according to him, the body was still moving.
That is all right.
So there is only Titan and PW 12 and PW 14.
Believe 14, if the medical evidence rules out ante-mortem hanging, and then as I said, 106 plus recovery of that hammer.
The recovery of the hammer also, Your Lordship, there is no forensic evidence which can connect the hammer to the injury or...
Doctor says hammer can cause it.
Yes, but he also says that the reason he says hammer can cause it is because it was mentioned in the police report, which he was aware of.
And hammer is recovered at the behest of...
And there is nothing found with the hammer.
PW 13 you show, Bhushan.
PW 13, I'll take, Your Lordship. That's the medical evidence. Page number 92, Your Lordships. Usually show it from the original report. Anyway, let me read from here. Let's see that. There may be some typos, Your Lordship. We were next the original record also.
Lordship, we see from the original record, the postmortem report.
Yeah.
What is it? Page number? Is it there?
You filed it.
Lordship.
Oh, no, it's not next to the. It's not next to the submissions. The original record will be with the report also.
Original must be, digital must be available.
It is available, Your Lordship. It's here.
Original record.
I'll read it to Your Lordship until then. Give me that.
It's not, there is no index.
Yes, it's going to be a little difficult. I was there culling out.
327 of the PDF. 327.
PDF, page 673 of the original record, Your Lordship. 673. Oh.
Mamata, this is the High Court.
Then, so hanging ruled out.
673 of the
327.
digital copy, Your Lordship has it. I have a set. I can read it from the computer. Yeah, no, this is fine. Shubho. I have a soft copy also. I'll read it from there. You can. डबल है मुश्किल होगा 48 yes form of recording 48 Is it the same? They've got it? That is the postmortem. That's the postmortem report. We'll take your lordship to the deposition of the doctor first, or your lordship would want to see the postmortem report.
The question is where you said?
Definition of doctor. Page 94, 92.
No, 93, but he says that is inaccurate and to read the original.
The testimony I'll take your lordship through first.
Yeah, where is the testimonies?
At page 48, internal 48, your lordship has got it. I've got a copy. Give this.
The original record.
Yes, your lordship. Here, your lordship can refer to mine. I have a copy on the soft copy also.
No, I have a soft copy, but I'm not, 48 is it?
Internal 48 of this, of the testimonies.
48 is something else.
48 is something else.
Okay. Yeah, to.
63 is the postmortem report.
Actually,
ये
lordship,
मैडम ये वाला देख लीजिए.
conclusion in the PMR, lordship, the postmortem report, the conclusion paragraph, lordship, it gives the entire details, lordship. That may be the last page of the postmortem report in handwritten, lordship. It's very clearly. There's no
I'll take them to that. Just reading the testimony first.
No, it is there. Deposition of PW 13.
Yes, PW 13.
Page 37. हाँ वो ओरिजिनल है दिस जेरॉक्स फोटोकॉपी बताओ ना
Lordships got it?
This, yes, photocopy.
Can I read?
Yes.
On 16/6/08, I was posted as MO at Boxnagar PHC. On that day, I conducted post-mortem on the dead body of Soma Acharjee, as was identified by Pintu Kumar Sarkar and others. On physical examination of the dead body, I found the following injuries. 1.5 and 1.5 small hematoma.
Half into half.
Half into half.
Serial number 1, half into half.
Half into half. I apologize. Half into half small hematoma over sternum, front middle portion of the chest. Half into half hematoma over right angle of the mandible, right side of the face, jaw. Third, half into half hematoma over the occipital area. No typical ligature mark. Yes, this one.
Yes.
As seen, a flat depressed measuring 3x5 U-shaped over left side of the neck was found. No abrasion or ecchymosis on that area was seen. There was depressed fracture of the scalp. No cervical vertebrae fracture was seen. The details about the injuries seen in the thorax region, abdomen and muscles, bones and joints are mentioned in the report at page 2 and 3. More detailed description about the external and internal injuries is mentioned in the report. From the external and the internal injuries observed during the post-mortem examination, in my opinion, the cause of death was head injury caused by a blunt weapon-like hammer. This opinion is mainly based on the injury number 3 above mentioned, which resulted in congestion of the affected areas. The consequent depressed fracture of the occipital area caused pia dura arachnoid matter of that affected area getting congested. The brain tissue of the affected area was also congested. The patient was later on put on hanging, so it was a case of homicidal hanging. The basis of this conclusion is that there was no typical hanging ligature mark on the left lateral side of the neck, where skin tissue was pressed, with an area of 3x5 U-shaped, where no abrasion or aclomosis was seen. This was indicative of circulatory failure. There was no inflammatory sign seen. The person was dead and so-called pressed area was below the thyroid cartilage. There was no congestion seen in the conjunctiva.
Was convicted for 201 also.
302 and 498, Your Lordship.
201. Case of 201 also.
There was no congestion seen in conjunctiva, eyelids, face, nose, pharynx, and tongue, which are generally seen in a case of hanging. Tongue was not also protruded. There was no vaginal discharge, no fecal matter was seen in the anus, which was generally seen in a typical hanging death case. I gave a detailed report regarding in the examination in my hand. This is my signature in the report, Exhibit 13 and 13.1. Cross-examination for the accused. I know Dr. Bin of the Tripura Health Service, and I am acquainted with him. We were posted at the GB hospital for a particular period. There may be exceptions regarding this. Dr. Bin, Your Lordship, there was some allegation that he was closely related or he was known to the father of the deceased. There may have been exceptions regarding the signs and symptoms than what is mentioned in this report. I have mentioned the word hammer in my opinion because the police stated that a hammer was seized by him and also because of the 3 injuries already mentioned above, which may be caused by blunt weapon, one of which may be hammer. In the dead body challan sent with the dead body, it is mentioned who is identifying the identifying police officer. In this case also such challan was there. This police officer is supposed to identify the dead body, although the 3 injuries aforesaid may be sustained if struck against a hard object. The injury seen may be sustained accidentally also by the person. Witness volunteers, this may be inflicted on the person as well. After sustaining these injuries, a person can survive for 4 hours. This is so particularly relating to the injury of the occipital region. By using the word homicide hanging, I meant hanging by others. In case of suicide hanging, the mode death may be asphyxia, synope, or coma. A person trying to commit suicide by hanging may survive if rescued within 5 to 10 minutes. Cretoid cartilage, thyroid cartilage, and cervical vertebrae may not be there in all the cases of suicidal hanging. It's not a fact that there will be no ligature mark, bruise, ecchymosis if long and soft ligature is used. When a soft, long ligature is used around the neck in a suicidal hanging and had no jerking from height, there will be pressure on the cartilage. I did not mention these intentionally as I was confused as to the real cause of death. I did not hand over the report to the IO on the date of examination. In some minimum case, there may not be protrusion of tongue. I cannot say on which date I sent the report to the IO. It is true that according to the medical jurisprudence, the copy of the autopsy report is to be sent to the SP of the district within 2 days. I have no specialization in forensic medicines and toxicology. All fractures in the occipital region may not cause death. In this case, considering the injuries in the occipital region, there has to be an internal hemorrhage. This hemorrhage was in this case. It is not a fact that such injury was not there. It is not a fact that my opinion about the cause of death was incomplete opinion. I have been in the Tripura Health Services since 29 Feb 1984 and have been performing the post-mortem examination since then. It's not a fact that my report is prepared being influenced by Dr. Bin and the parents of the deceased. Your Lordship, may I take Your Lordship to the post-mortem report also then? Is it typed anywhere? Is it typed in a copy?
This postmortem evidence says 16/6/2008. Is it a mistake? The opening part of the deposition.
2007.
7 it has to be, no? Typographical error, right?
There's mistake. The incident is
Page 63 is the postmortem.
So the same day he has done the postmortem report.
What is important is that the time and cause of death is not very clear. There is nothing mentioned. The injuries, it's possible to be alive after the injury also for some
Where is the
hours.
postmortem report?
Yes, Your Lordship. It's in the records itself. there's no typed copy, Your Lordship, of the postmortem
Page
report.
63 maybe, Lordship.
Yes.
Bit tough to read, huh? Hmm? Those are the details of the injuries. Should I read the detailed description of the injury of the deceased, Your Lordship?
Due to head injury caused by blunt weapon like hammer,
Yes, Your Lordship.
she was put on hanging.
That's why he calls it a case of homicidal hanging.
The opinion is mentioned here.
Which is his death. The ligature marks. There's no distinction made in terms of what could be before death, the injuries, and what can be after, Your Lordship.
No,
Because she's got mark on her neck, etc., but
on her neck, but that is
hematoma over certain areas, whether these are antemortem, etc., there's no distinction made. There was abuse involved in the sense of dowry is being suggested, but whether these injuries were caused because of which, or is it because she fell down or accidentally hit herself? But the fact that she was found hanging is there. Only question is when she was found hanging, whether she was alive at that point. And whether it is the husband who has caused it.
In detail, this doctor has said that she was not alive. First, she was
homicidal hanging, that means
injury was caused by hammer, and after she died, it was hanged.
Because the sign of suicide would be different, that there'd be protruding tongue. Although he says in not all cases will there be protruding
That's
tongue.
homicidal hanging is misnomer. It is not a case of homicidal hanging that you hang for committing murder.
Correct, correct.
That is not
And the
case
cause of
here.
death is not connected directly to the hanging in this case.
Homicidal death is contradicting doctor's earlier part of the statement that he died because of the head
The injury is caused to the head, possibly by the hammer, as he says.
But he explains what I mean is that she has been hung to give an impression of
by other means, hanging to by other means.
Otherwise, he is clear there's head injury.
And he gives reasons why he says that he died because of head injury and not because of the hanging. In detail, he says that the features, internal features, which the doctor would find in the body when death is because of hanging.
Those are missing.
Basically, the tongue will protrude.
Ligature marks, the vertebrae may break, the cartilage under the thyroid bones, etc., may break. All that is not seen here. Now, whether the injury was caused by the hammer is not clearly, except the doctor's report, it can't be proved, Your Lordship. Whether
14 is clear, the child is clear.
With this,
He is inside jail. Sorry, he is absconding. He absconding. We have granted bail or why?
no, Your Lordship, I think he was
In what
out
way
on
he is
parole by
absconding?
the state and
On parole, and then he was supposed to report back in 30 days. In 2014.
Oh.
So he,
Lordship, may not be all that relevant, but when the sentencing issue was being considered by the trial court, in the sentencing part, the court records that he volunteered that I have done it and I have repented. That may not be, Lordship, in that sense. Not be there.
only other thing is, Your Lordship, therefore, sans any clear medical evidence or forensic evidence which suggests how the husband hung the body.
313, Lordship. Since Lordship brought up the issue of 106, Lordship may also want to just have
I was telling brother, he has no doubt in his mind. We are wondering what to do.
She was 15, Your Lordship. She was 15.
19.
15 at the time of death.
19.
Sorry, I'm so sorry. 19.
An old story.
15 at the time of marriage, but mentioned.
After a death reference, the court pronounced acquittal. So the lawyer, amicus curiae, like you, he sent a telegram because those days no phone. Justice has triumphed. Reply came, appeal immediately.
Only one last leg, Your Lordship. I've shown Your Lordship the medical evidence, the evidence with respect to the ocular evidence. Place quickly a few judgments
Yes.
before Your Lordship. I've given Your Lordship the compilation. I've also culled out the relevant paragraphs from those judgments. In this compilation, there are also two judgments with respect to dwelling house. There are about 6 to 7 more judgments on dwelling house. If Your Lordship would want to see, I'd place those also before Your Lordship. But these I found to be helpful for the petitioner. I'll take Your Lordship quickly through the part submissions with respect to this. Page 8 of the submissions, Your Lordship. And then I'll take Your Lordship through the judgments. It's respectfully submitted that the conviction of the petitioner is founded primarily on an adverse presumption drawn from 106 on the reasoning that the occurrence took place inside the dwelling house of the petitioner and that he failed to explain how the deceased came to be found hanging. It is submitted that while Section 106 may permit a limited inference in appropriate cases, it is settled law that such presumption cannot displace the primary burden on the prosecution to prove guilt beyond reasonable doubt. It's submitted that this Honorable Court in Mushir Khan, 2010 to SCC 748, the paragraph is paragraph 45. It's not mentioned in the submissions. I'll place it before Your Lordship. It specifically said, it seems therefore to follow that whenever force a presumption arising under Section 106 of the Evidence Act may have in civil or in less serious criminal cases, in a trial for murder, it is extremely weak in comparison with the dominant presumption of innocence. In the Constitution bench of this Honorable Court in Govinda Reddy versus State of Mysore, it has been held that the mode of evaluating circumstantial evidence has been stated by this court in Hanuman Govind Nargunkar versus State of Madhya Pradesh, and it is as follows. It is well to remember that in a case where the evidence is of circumstantial nature, the circumstances from which the conclusion of guilt is to be drawn should be in the first instance be fully established, and all the facts so established should be consistent only with the hypothesis of the guilt of the accused. Again, the circumstances should be of conclusive nature and tendency that they should be such as to exclude every hypothesis but the one proposed to be proved. In other words, there must be a chain of evidence so far complete as not to leave any reasonable ground for conclusion consistent with the innocence of the accused, and it must be such as to show that within all human probability, the act must have been done by the accused. The learned counsel contended that though the crowbars were purchased by the appellant 2 and 3, it might be that the said crowbars were handed over to the real culprits for committing the murder, and the appellants, these were the facts of the case. The principle that the inculpatory fact must be inconsistent with the innocence of the accused and incapable of explanation on any other hypothesis than that of guilt does not mean that any extravagant hypothesis would be sufficient to sustain the principle, but that the hypothesis suggested must be reasonable. Para 19, Your Lordship, it has been held by this Honorable Court that Section 106 of the Evidence Act does not directly operate against either a husband or wife staying under the same roof and being the last person seen with the deceased. Section 106 of the Evidence Act does not absolve the prosecution of discharging its primary burden of proving the prosecution case beyond reasonable doubt. For this, Your Lordship, I have placed 2021 5 SCC 626. In the present case, the presumption under Section 106 has been employed as a substitute for proof, despite the absence of any direct evidence, absence of forensic linkages, and absence of any eyewitness to the act of assault or hanging. Such use of Section 106, it is submitted, results in an impermissible reversal of the burden of proof and renders the conviction legally unsustainable. In the present case, statement of PW12 indicates that he was present at the time of the incident took place. It is settled that 106 has no application to cases where the fact in question having regard to its nature is such as to be capable of being known not only by the accused but also by others if they happen to be present when it took place. For this, I've relied on Balbir Singh, which is the last judgment in this compilation. They have not, in this case, Your Lordship, led any evidence with respect to the family members who had otherwise given the boy's side of the view. I've said that at para 25. And the petitioner in this case was the first person to inform the father of the deceased. The father of the deceased went straight away to the police and recorded the izhar. Such conduct negates any presumption of concealment or guilty knowledge and militates against the drawing in of an adverse inference under Section 106 of the Evidence Act. Further, the medical and factual records show that petitioner was, there is some bit about how the petitioner was incapacitated for a long duration around that time. That evidence has also not been considered. Para 28, further at page 71, he's acknowledged that the petitioner had met with an accident and remained admitted. Same about his incapacity. Sorry, with respect to? Your Lordship would want me to show the paragraphs in the judgment, out of which there are two judgments. In fact, the judgment number 4 and judgment number 3, both are cases of dwelling house. Balbir Singh, I'm not sure.
You have not mentioned the paragraph?
I've culled out the paragraphs also. I've mentioned, no, I have not mentioned the paragraph in the compilation. I'll give it to Your Lordship straight away. The first judgment, we are relying on para 45. I'm so sorry, I should have mentioned, Your Lordship. Para 45 in Mushir Khan. In Govinda Reddy, which is the Constitution bench, we are relying on para 5 and 10. The three other judgments, Your Lordship, are with respect to dwelling house, where the husband and wife were found to be in the same area. Para 22, in case of state of Rajasthan versus Thakur Singh. And with respect to Shivaji Chintappa Patil, para 23. There was more in Shivaji Patil. Your Lordship, there are some more paragraphs I wanted to read in Shivaji Patil, I think. Sorry, that's in Balbir. Balbir, Your Lordship, para 45.
Where do you get this fact that the accused convict informed the father of the girl?
Oh, that father of the girl is mentioned in one of the depositions, Your Lordship.
No, whether father is saying so.
PW7 is Sopan Acharji, the father.
It's the father. The father's testimony, Your Lordship, also has changed since the beginning. The izhar didn't mention the role, the same role as the thing, but I'll just read it out to Your Lordship. There's PW7's testimony.
No, he lost the FIR, father.
He says.
No, but what?
It should be in the FIR itself.
Correct.
Yes.
My son-in-law informed me.
Yes.
Also recorded in the impugned judgment at para 8, Your Lordship. Para 8 of the impugned judgment specifically records it.
Doesn't say that.
At 8 a.m. in the morning, the informant got information. Achha, it doesn't say that.
It says information.
The izhar. Correct.
Deposition says. Deposition says that.
Whose deposition?
Father's deposition.
PW7, Your Lordship.
In June at 8 a.m., Gaur Acharji is the petitioner. Informed me over telephone that Soma is his daughter, has committed suicide by hanging.
Is PW7?
Yes, Your Lordship. At page 65, the PW7's testimony is there.
Yes.
Should I read out PW7's testimony also? At page 70, Your Lordship, in middle of the page. On the 16 June 2007, around 8 a.m., Gaur Acharji informed me over telephone that Soma had committed suicide by hanging. Hearing this, I went to the Kalam Chaura PS police station along with Gopal Acharji, and the local people of my area went to the Kalam Chaura police station. Near the police station in a shop, on my dictation, a complaint was reduced in writing and I put my signature in it. This is my signature. Thereafter, with the police, we went to the house of Gaur Acharji and found the dead body of Soma hanging from the roof in the southern Bitti room. As it was brought down, a black spot on her neck and another on her chest. Police prepared a report after seeing the dead body and obtained my signature. This is my signature. Thereafter, the dead body was sent to Boxnagar PHC. All the 4 accused are present today in the dock.
Yes, you have finished?
Yes, Your Lordship.
So Lordships have seen the evidence, Lordship, in the, just want to take Lordship to the original record once more at page 50, page 60 and 61, Lordship. The original record at page 60 and 61, which has the sketch map. The sketch map, Lordship, would see few houses are drawn there, Lordship. And the one at A, there's A, B, C, D, E, F, G. The one at A, so Lordship would turn the page over. Page 60, Lordship. I have this.
The other file.
In the same volume.
Same volume?
Where the postmortem report was there.
Yes.
Just one page before that.
Just after the postmortem report.
Before postmortem.
Just after the postmortem report.
That is some letter.
There's a sketch map like this.
60.
60. Postmortem.
Yes, I'm referring to various houses drawn here. The A, Lordship would turn over the page and see that A is the PO, place of occurrence. Then say A is the PO. And then what is A, Lordship, is written is the dwelling house of Shri Gaur Acharji, which is the petitioner, the appellant herein, son of Bimala Acharji of Kamal Chowk. Now, Lordship would see B is actually the cowshed of Bimala Acharji, his father, who is the co-accused and has been acquitted. C, Lordship, is the dwelling house of Shri Bimal Acharji. Is his father co-accused, acquitted by the trial court. So, Lordship, the query that had fallen from Lordship that the dwelling house is of the couple. His father was not there, Lordship. That is primarily the reason, Lordship. Father was acquitted by the trial court and subsequently, Lordship, the mother and the brother-in-law also.
There is PW 14 living.
PW 14 is also a neighbor, Lordship. What is his name?
Not in this compound.
No, Lordship. I'll just get the name.
Bimal is his father.
Bimal is his father, Lordship. Yeah, Jatindra Das's house is not shown, Lordship.
No, it is shown.
It's shown, Lordship.
Jatindra Das is EFG.
EFG.
That's
yes, Lordship. Yes. Oh, I this handwritten. I just.
PW 14.
He is PW 14.
And that child?
Titan. Bimal, then Chitta, then Pradeep Sarkar, and then Titan is not shown, Lordship. But G, Lordship, is correctly, Lordship. Lordship correctly.
Jatinder Das.
Jatinder.
Jatinder is that neighbor.
Neighbor, Lordship, who had come and seen the hanging.
12.
PW 14. 14. Who saw the appellant also, Lordship.
So in any case, what you are trying to suggest is
Lordship,
that the houses are different.
Houses are different. It was
even if they are acquitted.
Yes.
106, only this petitioner can be acquitted because he was staying separately.
Yes, Lord.
It is not that in the one chawl or one premises, all the houses were there.
Everyone is staying.
They are different houses.
Yes, Lordship. That is the sketch map also suggests that it's
It says there is a road, this road, and
Yes.
beside the road, they have a different houses.
different houses, Lordship. Now, just one judgment, Lordship. And Lordships have followed it in the case of Balbir Singh also, where Lordships Justice Mishra is also a party in that. Lordship, this 2006 Lordship.
Timothy
Maruti.
That is the leading case.
Yes, sir.
That is GP Mathur.
Yes, Lordship. Justice the JP Mathur and Justice Ravindran, Lordship. And just read one paragraph or maybe 2-3 paragraphs from that, Lordship. Paragraph 15, Lordship.
Has been dealt with in one of these judgments. It's been dealt here at page 39 of Shivaji.
Paragraph 15, Lordship. May I read?
Yes.
Where an offense like murder is committed in the secrecy inside a house, the initial burden to establish the case would undoubtedly be upon the prosecution, but the nature of the amount of evidence to be led by it to establish the charge cannot be of the same degree as is required in other cases of circumstantial evidence. The burden would be of a comparatively lighter character. In view of Section 106 of the Evidence Act, there will be a corresponding burden on the inmates of the house to give a cogent explanation as to how the crime was committed. The inmates of the house cannot get away by simply keeping quiet and offering no explanation on the supposed premise that the burden to establish its case lies entirely upon the prosecution, and there is no duty at all on an accused to offer any explanation. That, Lordship, para 15, Lordship, and para 21, Lordship.
Yes.
In a case based on circumstantial evidence where no eyewitness account is available, there is another principle of law which must be kept in mind. The principle is that when an incriminating circumstance is put to the accused, and the said accused either offers no explanation or offers an explanation which is found to be untrue, then the same becomes an additional link in the chain of circumstances to make it complete. This view has been taken in a catena of decisions. In para 22, Lordship, where an accused is alleged to have committed murder of his wife and the prosecution succeeds in leading evidence to show that shortly before the commission of the crime, they were seen together, or the offense takes place in a dwelling house where the husband also normally resides, it has been consistently held that if the accused does not offer any explanation how the wife received injuries or offers an explanation which is found to be false, it is a strong circumstance which indicates that he is responsible for the commission of crime. Then Lordships have gone to the judgment. Now, Lordship, 313 statement of this appellant, Lordship, whether he has offered explanation, Lordship. Lordship would find it in the original record only. May I refer it from the original record?
Here it is here.
It's just after the postmortem report, Lordship. Just after the postmortem report. Lordships would see, Lordship, questions one after the other. Gaur Acharji is the appellant here in Lordship.
Which question?
Question number 27, Lordship, just that, the last question, of course, is the most relevant one, but 27 here, he also confirms that there was a demand of dowry. TW7 has deposed that he managed the money within 7 days and informed Gaur to come and take delivery of the motorcycle, and accordingly it was delivered to him. What do you have to say? He says that the motorcycle was given after about 3 months of the marriage.
It is not there. It says nothing here.
I was reading 27, Lordship. Then
27 only.
Then, Lordship, question number 40, Lordship, he says that meeting took place. He admits to the meeting. There was a meeting that took place because of the torture and all that when the wife complained, Lordship.
Okay, let us see whose 313 is this.
Gaur Acharji, Lordship.
Case of the accused persons.
Oh, Lordship, may I see that? May I see?
Oh, this is Aarti Acharji. Sorry, you are right.
I am reading page 6.
Acharji.
I am page 66, Lordship.
And it doesn't tally like that. 27. Yes, now it is here. Yes.
Lordship. And then
Other
in question 27, I read, Lordship, where he had in a way admitted that there was a dowry demand. He said that I received the motorcycle after 3 months. He says that, Lordship, at question number 40 and several other questions, Lordship. Question 33 also, Lordship, they say that PW7 has deposed that on 27/5/2007, a meeting was held again in the house of Ranu Das, which was attended by both the parties, so and so, Pradhan of the Panchayat, the members of Upa Pradhan and others. In the meeting, Soma complained of torture upon her by the accused persons. What do you have to say? The meeting took place in the house of Dropal Das, but Soma did not make any complaint, he says. He did admit of such meeting taking place. Lordship, question number 40 also again talks of that meeting. These meetings are, Lordship, these meeting is actually where I will have the resolution also, which is on record, which is a written resolution signed by all the parties, which is 20 days before the incident happened, Lordship. And Lordship, when PW 14 is put to him at question number 53, Lordship would come to question.
Question 40?
Question 40 is, Lordship, is again about that meeting, Lordship. PW 9 also deposed that.
Is the answer.
The meeting took place in the house of Gopal Das, he says, adjacent to the house of Ranu Das. Where he said that house of Ranu Das, the meeting took place. He says that meeting took place in the house of Gopal Das. And they say Soma made no such statement.
And thereafter, Gopal Das adjoining house of so. Then thereafter?
Ranu Das, Soma is the wife, made no such statement. Question 53, Lordship. Question 53 is the most relevant.
Sir, there is in question, there was a. Yeah, you read 53?
Yes, Lordship. Question PW 14, Lordship, is the witness, the neighbor, Lordship, who was. PW 14 has deposed that he found the body of Soma hanging in the ceiling and he looked downwards, but it did not find any stool or like that. He was wondered how she could hang herself. What do you have to say? Then answer to that, he says there was a generator below. And generator, Lordship, would his explanation, generator, Lordship, is generally a hanging. I mean, just Lordship saying that a hanging, if someone is standing on a generator, Lordship, someone cannot just push away a generator. Generator is something more than 20 kgs, Lordship. Normally, that's normally the way it's used. That is one explanation. Small generator, Lordship, generally the generators are, Lordship, big generators. Normally stool or something in a case of suicide, genuine suicide, Lordship. Someone may be standing on something, kicks it away or something like that. Then, Lordship, the last question, Lordship. Do you have anything to say about the case? I am innocent. When I was in the lockup, Sopan Acharji threatened me that he would see me. So that is, Lordship, no explanation as to anything that he was there in the dwelling and house and how the wife sustained, Lordship, the injury, Lordship. Nothing, absolutely nothing on record, and Lordship, in light of the law that Lordships have laid down, Lordship. The owner's, Lordship, would even reinforced in view of section 106, Lordship, that the owner's obviously, Lordship, would be on him, Lordship.
Yes.
This judgment, Your Lordship, is also being dealt with in Trimurti Maruti Kirkan is being dealt with in that judgment, Shivaji Chintappa Patil. At paragraph I saw it, Abhina, where is it? Just give Your Lordship the paragraph. At paragraph 21, Your Lordship.
21.
Yes, Your Lordship. This court, they refer to these judgments, there are more than one, Trimukh, as well as Ponu Swami versus State of Tamil Nadu. And then
which
they,
case you say? Shivaji Paracha.
Your Lordship, at page, starts at page 32. It's also a case of dwelling house. The husband and wife were last seen at night together. In the morning, the husband opens the door and says that the wife has committed suicide. The husband was tried and finally acquitted in this case. I may, although admit here, Your Lordship, the difference between the two cases in this perhaps could be the nature of injuries. In this case, as Your Lordship will see at para 21, in both the aforementioned cases, the death occurred due to violence. In this case, there was no mark of violence. The appellant has been found. So the reasons how they are distinguishing between Trimukh, etc., is because in those cases, there was violence found. In this case, at para 23, your lordship holds that it's just because the husband and wife share the dwelling house can't be a reason for 106 to trigger singularly. The nature of injuries which have been found in this case could also have been caused by various other reasons, and whether they were proximate to the time of death is not something the post-mortem report indicates. There's plenty of evidence which does indicate that she was abused for dowry. And they have been charged for dowry, your lordship. Much obliged. So such a
What will be
patient
the normal reaction if somebody sees someone hanging?
is not to lie down on the bed.
No, not one. Have to bring them down, no?
Yes, your lordship, but perhaps because all the neighbors and everybody came, I don't know why they didn't bring it down. The police came after 2 to 3 hours, as is indicated by PW14's
The
testimony.
husband, he would have called people to bring her down.
As per Titan's testimony, your lordship, it shows that the husband was not in the room. It's only when Titan screams that PW14 then comes to the room. The time lapse is between 6:30 to 7. So it's not very clear, but Titan seems to be the first person to get to the incident. Then Jitendra Das comes around, PW14 comes.
Titan doesn't rule out his presence. Titan may not speak about it.
No, he's specific. I'll take your lordship to Titan's testimony again. What page is this?
What number is he?
PW12, your lordship, at page 89. Not see anybody else in the room, specifically, lordships. I know Gaur Acharji, who's my adjacent neighbor. 1.5 years back, one morning around 7 a.m., I went to his house to bring my pen. As I was searching the pen in the room of Gaur Acharji, I found the body of his wife, Soma Acharji, hanging from the ceiling in the partition portion of the room. Seeing this, I crowded out and returned home. I did not see anybody else in the room. He's found to be hostile.
With the partitioned portion.
And he denies specifically that he had made any statement to the police that Gaur Acharji was lying in the bed. However, 14 then goes on to say that he found Gaur Acharji lying in the bed.
161 says, I told Gaur Acharji that your wife is dying, and then he told me to go home.
He says, I have come to the court with the accused person.
The accused person.
Where's that bit?
Lordship, also just one more thing, Lordship. That's the areas of the situs of the injuries, Lordship. One in front of the chest, one in the mandible region, and the occipital region, Lordship, may, according to my understanding, with the backside, Lordship. This cannot result in a fall, in a free fall or something, Lordship. It cannot result from that unless there is a deliberate injury being caused, Lordship.
The doctor's testimony specifically doesn't rule it out, your lordship. He says it could be caused because of a fall or by certain other means.
In the front of the face, one on the back of the face, Lordship.
No, but it is not your case that she had fallen.
Yes.
No, he doesn't put
That
up
she hanged herself.
he doesn't put up a defense at all, in fact.
So a third case is put in cross-examination that this might have been caused because of fall.
Yes, he just leads
There
some
was
cross-examination. Yes, your lordship.
nobody's case that there was a fall.
Yes, Lordship.
But with some evidence
Yes, Lordship.
to corroborate that part of suggestion.
At the testimony of the
Answer
doctor.
to that suggestion by the medical officer. There should be some corroboration that.
Unfortunately, they have not raised any defense. I'm so obliged for such a patient hearing, your lordship.
Third learned counsel for the part.
Much.
For the
Much obliged, Lordship, for the patient hearing.
trial court का record भी काफी है.
Thank you.
ये नहीं रखिए ना. हाँ, technical. वो जो रिटर्न सबमिशन है ना, इनका उसी में स्टेप कर देंगे. Yes, Mr.
For appellant.
For appellant, your lordship.
For appellant, start.
Arguing counsel, your lordship.
We know, therefore.
Arguing counsel is not.
Not
is a
well?
for today and tomorrow, your lordship.
Today and tomorrow he is not well.
No, is in some difficulty for.
Difficult.
Where is Miss Bharti Upadhyay? She can argue, get her.
A senior.
All Bharti, she can argue, she is quite competent.
Who is Bharti?
I am new. I have been appearing from today, your lordship. Since I am new for.
So you are new. Bharti is not new. What brother is saying that Bharti can argue the case. You know Bharti?
No, your lordship.
You even know Bharti.
I knew. Ashwin V. Kotamat, I knew him as senior.
Ravanna is in appeal.
Yes, my lord, is the complainant, my lord, one of the.
So it's with
Against Acquittal.
Against Acquittal.
leave to file.
Permission to file SLP, my lord. The trial court has convicted, High Court has acquitted, my lord, all the accused.
What offense?
Lord, the offences under 302 and others offences, my lord. 143, 147, 148, 341, 302, 307.
Who is Ravanna?
Revanna was one of the relative of the deceased, my lord.
Relative of the deceased.
The High Court on legal points said that the complaint, the incident has taken place at 5:30 in the evening and the FIR was reached at midnight, my lord. Immediately after the incident, police was available. They only transported the body to the police station.
No eyewitness.
No, injured witnesses there. They turned hostile. And the body was sent to the hospital by the police, my lord. And after around 12:30 only they registered the FIR. So there was a gap. The High Court says that it is not a true FIR. It is hit by section 163 of 62 of the CRPC. And the witnesses are not.
But the eyewitnesses have turned hostile.
Most of the eyewitnesses have turned hostile, my lord.
Sir, many.
My lord, there are 20, the eyewitnesses is only 5, my lord, 4 or 5. They have turned hostile, my lord. And High Court on legal point, it says that
all eyewitnesses have turned hostile, or some have turned hostile, some had supported the prosecution, but disbelieved by the High Court.
Disbelieved by the High Court, my lord.
By the High Court. Even those eyewitnesses have not turned hostile, they have been
disbelieved.
Yes,
my lord. En masse, the family has been made accused, my lord. That is also one of the reasons saying that en masse, the entire family has been roped in as an accused. So the case is not proved. High Court says these are all planted witnesses because there are about 7 hours difference between the time of the incident and the registration of the FIR. The FIR is not the actual FIR, it is hit by section 162 of the CRPC.
All are accused, nobody has committed.
Pass. 2005 is the incident.
He is not ready.
Allahabad, we are getting 1980.
Papers you have?
I appear for the state of
Senior
Karnataka, my
Lord.
lord.
Senior
Respondent
papers.
number 8.
Will remain in the list.
Sorry,
Tomorrow is not well.
Next Wednesday. कर देना.
Bring him secretary.
As your lordship.
Please.
Was I beg
As
to appear for the
office
petition?
report, lordship, pursuant to. I'm sorry. As per office report, lordship, pursuant to last December, it seems that the district judge has calculated a lot on the report. Can we